Good morning. Oh, everything's still playing. Hang on. I don't know what's happening. There we go. I think I'm good. Oh my goodness. I've started out 2 streams just great. There we go. I'm here. Sorry. Good morning, Gabby. I was, on the phone with Carmen for, like, 3 hours this morning. Don't worry. We solved the, world's problems, but that made me run a little bit late, so my apologies. And then my, Rumble stream started playing volume. So I thought I still had stuff going. Good heavens. Yay. Alrighty. I promise I'm not always like this most of the time. Uh Gabby, I was thinking I had something for you, but I don't. There's no update on uh anything going on with the Florida trial yet. I'm not sure that judge, he's not even like listed on where you can go click on judges to see their stuff. He's not listed. So I don't, unless Court TV or Law and Crime streams that hearing, I don't know that we're going to be able to catch it. I'll try to keep looking though. Um, I don't know, but we'll get a trial date that day. That I am 99% positive will happen. Alrighty, I just need to take a breath real quick. Let me get this going. And then take it back. Alrighty, so we are going to finish the final day of the Martice Fuller trial. We'll do closing arguments, skip jury instructions. Okay. You know what? I'm jealous of you. You're going to pick up your glasses. I've been waiting 2 weeks for my new ones. They have not called me. They better call me today. All right. So we've got the final day of Martice Fuller. There's a little bit of argument in the morning before they do closings. So you will get the thrill of Mr. Gravely. I know y'all love it and want that. And then he does the first part of the closing. So the state goes first and then gets rebuttal. It's long. I think it's as long as her opening was, but probably is going to feel like 6 months. I know. I need to call them. But generally, they're really good about just texting and saying, hey, your stuff's here. Never had them not text and tell me that, but they're going to get a call today. So hopefully I can go pick them up tomorrow. All right. So anyway, there is a little bit of discussion between the attorneys. They exit. They're out for a little bit, but obviously I've got timestamps on that, so we'll skip by that. Gravely's in Gravely form. I'll just put it that way for his their last day in court on this. He's great. When I was listening, I didn't listen to it. I have no idea about a lot of things, but I just had to do timestamps, so I saw enough. More than I wanted. So I think I've got it where they're just coming in. I'm gonna make sure I have it turned up all the way. And might want to share the screen with you guys. That'd be great. I'm a little. Oh, are they? Wish I could see a picture of them. I'm jealous. Why is this not going? tell Carmen she has to stop calling me in the morning. Come on, Judge. I know you start talking here in a second. She's going to start. There she is.
Statements of defendant, which is
No, no, it's
180. 275, cautionary instruction, evidence of other conduct. There are two of those. One that was drafted by the defense, which is regarding the solicitation of communication with jurors. And it was approved by the state, agreed to by the state, and approved by the court. And then there's the second one, the cautionary instruction, evidence of other conduct. Mr. Johnson, you can make your record.
I know.
Your
You
Honor,
take your mask off.
specifically, we object to the portion of the instruction that talks about identity. We don't think that that is appropriate here, that there is, the instruction talks about that the prior conduct was so similar to the offense charge that it tends to identify the defendant. We don't think that the prior conduct that the state is introducing is so similar that it would tend to identify the defendant. It's not so unique or so similar. And so we don't think that that portion of the instruction should be read.
Mr. Gravely, or Ms. Gabrielle.
Your Honor, the state does believe that that language should remain in the instruction. The state's motion for other acts, which was admitted, was argued that all these other acts step by step lead us to the identity of the person who killed Kaylie Juga, and that the similarity in the acts is the similarity among the domestic violence acts, that this is a pattern of a domestic violence relationship throughout the course of both their time together and their time apart. And so this does directly travel to the identity of who murdered her.
And the court ruled, is ruling, as I did last night, that it is going to stay as it has been drafted by the court. Then we go to 162, agreed facts, and the request by both parties was that I not read the agreed facts in the criminal complaint of the pending jury issue, and not read the agreed facts or the stipulation on admissibility and chain of custody on the various pieces of evidence and the films. We'll get to a question of whether or not they can have those agreed facts and stipulations if they ask for them, but we'll talk about that later. Remarks of counsel is 157, 155 exhibits, 148 objections of counsel, 147 improper questions, 190 weight of evidence, 195 jurors' knowledge, 300 credibility without the paragraph on the defendant testifying because he did not. 315, defendant elects not to testify, was requested by the defense, correct, Mr. Johnson or Ms. Scheidegger?
That's correct.
Okay. 141, identification. 200, expert opinion testimony general. Expert opinion hypothetical, which is 205. And 201, opinion of non-expert witness. And we included in there Detective Kennedy, allowed to give an opinion on relative height and speed of a runner, and Ms. Schwensen gave an opinion on issues of domestic violence. 325, impeachment of witness, prior convictions, and there were two witnesses that had prior convictions. Closing arguments is 160. Then 460, closing instruction. The verdicts we worked on last night and they were approved, and then unanimous verdict. Any objection to, other than those stated on the record thus far, any objection, Mr. Gravely?
No, Your Honor.
Miss Gabrielle, sorry.
That's okay.
And any objection, Mr. Johnson?
No objection. I know we did, though, talk about on the verdicts that we just needed to change the date in the second question of the verdicts.
I did.
assume that was
I
done.
did.
Okay, thank
I
you.
used that whiteout thing and wrote with my pen.
Okay.
Okay, everything else all set? Everybody all set? The exhibits are down here, Mr. Johnson, Ms. Scheidegger, if you need those. And I think we're ready to go.
Your Honor, could we have just a minute, please, before the jury comes in?
Say that again?
Could we have a minute before the jury comes in?
Okay, Mark, to put the hold, okay, yes, we can.
So I wanted to put on the record a clarification. We've discussed this with with the attorneys for Martice Fuller yesterday. The video that showed a bike rider that was played yesterday, during cross-examination, Attorney Johnson had Detective Kennedy go to a point that was 54 minutes into the first segment of video. To some, that may have given the impression that at 2:54 p.m., this person in gray with a backpack was riding out of the Horizons neighborhood. Turns out that, in fact, it's because of the way it was captured on the video or transferred from the video, and depending on what player you use to show the video, it gives this impression. If you play it on the player that I used when I watched it, in which Detective Kennedy, the timestamp actually stays on the screen. And at 2:54 p.m., no one rides past that Nest doorbell. So I wanted to put that on the record. We talked to Attorney Johnson about this. He is aware of it. He has indicated he's not going to argue that in closing argument, but for purposes of the record, we wanted this to be clear.
And just so that we're as clear as we can be here, that we have reviewed that entire video from that afternoon. There's only one time that that bicyclist passes at that place, and that is that time at 3:03 p.m. or right around between 3:03 and 3:04 p.m. So I don't think counsel disputes that, but we don't want there to be a situation where, for appellate court purposes, if the defense, having had that in evidence, fails to argue it, that they would in any way be ineffective, because all parties, I believe, are aware that this has to do with how it's spliced and how it, if you play a video, depending on what the player is, it would indicate a different time, because it's the player that then is dependent. It's not.
You're talking about the player counting, the counting
Right.
mechanism of the player, not
Exactly.
time.
Not the
Correct.
time.
Correct. So I believe counsel, I believe that defense counsels understand it. We just simply want the record to be clear, because defense counsel has indicated they do not intend to argue that, because I believe that they
And
know.
would the jury be under an impression that it was 2:54 and not 3:03?
Well,
did we talk about that time, or did we say?
I believe counsel was careful. He said, based on the timer here, is that at the 54-minute mark? So I don't believe that counsel ever said it was 2:54. But I do think a juror might reach that conclusion. I intend to indicate in my argument that the only evidence in this case is that the detective reviewed this. There was only one time that this bicyclist went through, and that was at 3:03. And to argue that that any playing that occurred in cross-examination was simply using exactly the same video, but using it through a different player.
A different counter. Call it a counter, because
Okay.
otherwise.
Okay.
Call it a counter, because everybody knows about
Right.
count to
So
this.
I intend to argue that, just so the jury is clear. And again,
Okay, so you'll clear it up there.
I
Mr.
believe-
Johnson, you agree with that statement by the state?
Not entirely, I don't.
Okay,
So I know the state is indicating that it was played through a different player. I don't believe there's any testimony about it being played through a different player. We played the videos, and I had it queued up to 54:37. It shows what it shows at 54:37. I think I can remind the jury and tell the jury that what they saw was something at 54:37 on that first clip. I understand the state is saying there's this issue with the player, et cetera. But if that's not testified to, I don't know how the state gets to argue that. If the state wants to come up with some other way to make the point that they want to make, I think they're certainly able to do that. But I don't think that they can give an explanation that's not been given, or that's not that Detective Kennedy did not testify to, and sort of say it's this issue with this player, et cetera, if nobody's testified to that.
Well, they could call a rebuttal witness this morning to do that, or it could be stipulated that it was the time, it was the counter on the device, not the time set.
So I
don't know if you can stipulate to that.
There's not a timestamp on the video. I certainly agree to that. There's not a timestamp. But what I'm saying is that the evidence that we presented is that Detective Kennedy testifies and says at approximately 2 o'clock, this person goes one way on the video. We said, cue it up to this time. It shows a person going a different way on the video. I think I can point that out to the jury that that's what they saw yesterday. I'm not going to say it's 2:54 because I can't say that it's 2:54. There's not a timestamp or counter on that. 54 minutes into that video, this is what's on it.
Well, when you play that same video using the other player, the other mechanism for playing that video, the time is on the screen. And it does. At 2:54 p.m., no one rides by on a bike. They ride by at 2 and at 3:03 p.m.
Yeah, frankly, we are providing in the district attorney's office an ability to play these. So, and then we're doing that simply out of convenience for the parties.
Defense attorney.
What?
We're not providing the DA's office.
The DA's office has provided Mr. Stute and the equipment, so out of courtesy for the defense counsel, in this case, private defense counsel or appointed defense counsel, to do this. So we are providing the machinery. We should not have a situation where the jury is exposed to what are absolutely false assumptions from the argument that's just been described, out of the courtesy of us providing these players in these circumstances. So, counsel had no obligation to tell us, listen, here's the snippet I'm going to play, which is a snippet based on that other player, that other counter. He had no obligation to tell us that. But again, that would not have been able to have been accomplished without the courtesy of us providing the staffing to do that. So we're simply suggesting some false information should not be provided to the jury because of us allowing that to have occurred.
How would you like to?
Well, I thought yesterday that counsel was indicating that they also knew that there is no bicyclist going through there other than at 3:03 p.m. So I don't know if counsel's now disputing that, but that was what I intended to say. I intended to say
he said he's not going to argue that that's a timestamp on it. He said, but he's going to say at 2 hours and 54 minutes into this tape, apparently.
I mean, if there's not a situation where we have a stipulation that that the bicyclist that was shown on video during the cross-examination is the same footage that was previously testified to have occurred at between 3:03 and 3:04 p.m., then presumably we need to somehow make a record of that. So whether we need to somehow supplement the testimony or in some fashion do that. I mean,
how would you like to do it?
For myself, I mean, my frustration is it's apparent. It's exactly the same video.
It's apparent to all of you because you're familiar with these pieces of evidence. Those tapes, I can tell you for people who saw them for the first time, nothing's apparent. It was difficult to even read, the date from this distance. So you four want to step into the hall and figure out a way to do it? Otherwise, we can have rebuttal.
Yeah, sure. Yeah, we can go out. We can go out.
Yeah, okay. Been smooth so far.
So they're going to go have a little discussion. I think it's about, I'm going to fast forward. It's about 20 minutes. I'm not saying he was wrong in the fact that the state provided that and all that. He just gets such an arrogance about him. Well, like they're just so much better. The state gave that. They wouldn't even have it if it wasn't for us wonderful state people. And also, it doesn't matter. And there's so much more evidence on whether or not he crossed that Ring doorbell at 2:54 or 3:03 does not, it wouldn't be enough to sway me. There's too much other evidence in there versus when he crossed that in front of that Ring doorbell, Nest doorbell, whatever it is. I understand you got to fight for everything, and I don't fault him for that. But, you know, it's just, it's not going to matter. I don't think it's going to matter. I would assume just the attorneys are coming in. I don't know why they've got sound and no video, because the attorneys need to come back in before they call the jury in. I wondered if they were going to mute their mic. Oh, whoops. I read that wrong. I've been off this week.
Mr. Gravely, any rebuttal witnesses? Oh, Miss Gabrielle, any rebuttal witnesses?
We're just going to continue our redirect, would be essentially what we're up to.
Oh, okay, I'm sorry.
I guess the jury wasn't. Sorry.
Detective Kinnessy? Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated.
Thank you.
Detective Kennedy, on Exhibit 75, which is the video of the person on the bicycle riding past the Nest doorbell camera, do you recall that?
Yes,
Did you review that video in its entirety?
yes, I did.
Starting from what time to what time?
It would have been 2 p.m. to 4 p.m., I believe, is when we captured the video.
And when you say 2 p.m., you're talking actual clock time, correct?
Correct.
Not timer time on the player that shows the video as it plays.
That's correct, yes.
And when you reviewed that video using the clock time, when did you observe a bicyclist in a gray sweatshirt with a black or dark colored backpack riding by that Nest doorbell camera?
They were riding east at approximately 3:03 p.m.
And did you see the bicyclist riding west at any time?
Yes, that was shortly after 2 o'clock p.m.
Now, Mr. Johnson had you look at a clip of video 54, at the 54 marker on the counter at the bottom of the screen. You recall that yesterday?
I do, yes.
And we saw a bicyclist riding by going east, correct?
Yes.
What time was that?
The true time on that was 3:03 p.m.
And so no one was riding a bicycle past that doorbell camera in a gray sweatshirt and a dark colored backpack at 2:54 p.m., correct?
That is correct. No one was riding past at 2:54 p.m.
So Detective Kennedy, this is Exhibit 65 on the screen, and it says 2 to 3 p.m., correct?
Yes.
So I would ask that we play at 2 p.m. Yes, I see that. Mr. Stute, this says 2:08 p.m. Pardon me? No, I don't know. Mr. Stute, could you stop that, please? I don't know.
Well, that IT guy's in trouble. He's been spot on this pretty much this whole trial. Yeah, Stormy is with her son, and Hamilton, I don't know what she's doing, but she said she wouldn't be able to be on here till after 3. So I don't know where she's at. I know. I, I agree. That's my feelings too. And then Chrissy's not here. It's a quiet morning. Roseanne's not here. That's fine. I'm still trying to figure out what I'm going to do Friday. And then Monday. If they don't have that, if they don't stream that hearing, I don't know what we're going to do. Sit and stare at each other. Oh, you're fine. You're fine. It's hard to change those things. I'm ready to write that down. That actually, that's, I seriously am writing that down because I was like, what am I even going to call this thing? Maybe casual cops and car chases. I don't know what to do. We'll figure it out. Though. Have to make sure that when I'm trying to find something, I'm not pulling it off of somebody else's. There's so many people.
I told people a long time ago, turn off the phones.
Uh-oh.
Off.
Ooh.
Off.
Ooh. Josh was using our mommy voice.
Okay, my apologies.
Okay, continue.
Okay, Mr. Stu, could you please advance the video to the 2:54 p.m.? Oh,
Oh. Wish William's gonna get fired. I know. She was mad. I thought she was gonna say ouch. That's what a lot of judges say. I don't know why he cared if this was a rebuttal or a redirect. I don't know why it mattered. She was nice enough to let you guys do it. And snapped her tiny fingers on her tiny hand. I didn't know there was such a long delay right here. I didn't watch it. I was just going by when people were doing stuff. She could kick the side of the booster seat or the bottom of her desk.
Okay, so now we ready?
yes, I apologize.
Just kidding. He's like, and I've pow-powed at people before. Like, dang, Judge.
Okay, the records reflect we're at 2:53.
May 9th, 2019.
Again, I just don't think this makes any difference. But I get it. You got to make sure all your T's are crossed and your I's are dotted. Hey, Roseanne.
So Detective Kennedy,
Morning.
2:54, 2:53 to 2:54 p.m. Does any bicyclist cross the path of this video camera?
No, no one does.
Then I would ask now we advance to 3:03 p.m.
They're arguing over timestamps right now, Roseanne, that are going to make zero difference. has been the Gabby Show for a minute. Also, Roseanne, there is no ruling yet on Chad Dorman's motion to suppress.
Thank you. Detective Kennedy, at 3:03, approximately 15, did we see a bicyclist in a gray sweatshirt with a dark backpack, white shoes, and jeans ride by?
Yes, we did.
I don't have anything further.
Mr. Johnson, turn on your mic. Okay.
When I looked yesterday afternoon, I haven't had time to look again this morning, but I doubt it.
So I want to go back to yesterday. So yesterday, video was played from the Nest camera from 109 1969th Street, right?
Yes.
Which is the same home that the video we just saw is from, correct?
Correct.
The video that was played yesterday didn't look it's not the same as how we viewed it yesterday, right?
It's the same footage. I believe it's a different player.
So yesterday we watched it in a way that did not have a timestamp on it, correct?
Correct. There was a counter.
And when you say a counter, you're talking about within the media player had its own counter.
However, the video was spliced. That's when the counter was from. So if you're asking that, that's my understanding of it. Whether it's contained within the media player, that might be true, but I'm not a technical guy. I just know that it wasn't true time. It was a counter.
Right. There's not something that says right now the video that we watched yesterday did not have a counter that said the time is 2:01 p.m. or something like that, right?
Correct. Yes.
Exhibit 75 is the disc that contains the video that we just watched, right?
I believe so. I'm not sure the exhibit number, but I mean, if you're telling me that, that's probably
Okay.
true.
That's what I think it is.
Okay. I would agree with that.
And you've reviewed the disc that has the footage from 109 1969th Street, right?
That is correct.
There are 2 files in that disc, right?
Yes, it's broken up in 4 hours, I believe, or 2 hours. I'm sorry, from 2 to 4.
So 2 hours, 2 files, right?
I believe so. Yes.
The first file is labeled 2 p.m. to 3 p.m.
Yes.
The second file is labeled 3 p.m. to 4 p.m.
Correct.
Yesterday, when you testified, you were shown on the other player the 2 p.m. to 3 p.m. clip, right?
Correct.
And at some point in that video, there is someone on a bicycle going westbound past the house, right?
Yes. So we observed the footage that we just saw of the same person riding eastbound through the house. The correct time on that would have been 3:03. Yes, I'm sorry. What we saw yesterday was the same footage that we just saw today. The correct time, true time, would have been 3:03. I believe it's 15 or 3:03:18.
Now, when the person on the bicycle goes westbound, that's not 3:03, that's earlier, right?
Correct.
Yesterday, you said it was approximately 2 o'clock that occurred.
Correct.
And then on cross-examination, I showed you that same video that we saw yesterday of the 2 p.m. to 3 p.m., right?
Correct.
And asked that it be advanced to 54 minutes and 37 seconds on the counter for the player.
Yes.
And at that time, it shows an individual on a bike going eastbound, right?
Correct. That is the same footage that we just saw. The correct time on that, again, is 3:03. 15. It's not 2:54:30. It's 50. However, that video is spliced. It's 54 minutes into that. The true time at that is 3:03 p.m. Just the footage we just saw. It's the same footage.
So even though the file says 2 p.m. to 3 p.m., I guess what you're saying is that's not correct, right?
I don't know how that specific file was spliced or played on the viewer. What I know is the correct time was 3:03 p.m. So I believe that's a counter. I don't know what time that starts on that specific file. I do know correct time. We see that individual leaving at 3:03 p.m.
Well, and we saw today that if you do the file on a different player, it looks, the way that time is counted is different, right? There's a timestamp on the one we just saw, right?
There's a timestamp on the one that we just saw. That was 3:03 p.m. Yes.
There's
So-
not.
Roseanne, I was with you. You missed Gravely arguing. They've watched the whole thing. They've all seen all the video, and the state was kind enough to give the defense the player to play the video. He was very kind of just condescending about that, in my opinion. So I don't know because those doorbells, right? They record in 10-second increments. I don't know. I am completely speculating if that's what they had to splice together. But unless they're going to put another person on a bike in that, or saying that it took a person out, like it took the real person out, I don't know what any of this has to do with anything. Well, so the people didn't change the time on their cameras. But what they're arguing about is, which I don't know why they didn't just show what they just showed, which has the time on it. They're saying the different players have different counters on them. So it's not actually, there's not even actually arguing the time necessarily. It's just arguing that this counter was at 54 and this was at, it's like, I don't know where he's trying to get other than confusion land. And yes, it has everything to do with nothing. Yeah. So they're talking two different things. They're talking actual time and the counter. I don't just play it on the same thing and then there isn't this thing. There isn't this argument that means nothing to be made if y'all just use the same equipment. And I mean, just use the same equipment in the courtroom. I don't care what you use in your offices. It should all show the same thing.
Not a timestamp on the one that we saw yesterday.
Correct. There was a counter.
Absolutely agree 100%. Sit down. Somebody's turned into a robot. I can hear it.
That's all I have. Thank you.
Okay, thank you. Anything else, Ms. Gabrielle?
Just to clarify, Detective Kennedy, what we saw yesterday and what we saw today is the same disc and the same recording, correct?
Correct. Yes.
The difference is when Mr. Stute double-clicked to open it yesterday, it opened in one player, and when he clicked today, it opened in a different player that showed the time, the actual clock time.
Yes, that's correct.
Nothing further.
No follow-up.
Okay, thank you.
Thank you.
All right, you guys.
Right, just hang on.
Ready.
Anything further, Ms. Gabrielle,
No, Your Honor.
Mr. Johnson, or Ms. Scheidegger?
I don't have anything further than what's been said.
Okay, that concludes the testimony. Okay, so collect the notebooks.
Please. So we're going to hear Gravely for a while. So I've warned you, out in your ears, whatever you need to do. He's doing the first part of closing. So be prepared to be yelled at.
Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions,
Ma'am.
regardless of any opinion you may have about the law.
All right, we're not listening to jury instructions. Got him. There he is. There he is in all his glory.
Court has given you. So now we'll do closing arguments. The state starts. Mr. Johnson, I believe, will follow. And then the state gets
Yeah.
rebuttal. So we'll start with that. Mr. Gravely.
See, even it doesn't even want to hear him.
Thank you, Your Honor. Your Honor, members, counsel, members of the jury, thank you for this opportunity, and thank you so much for your patience in this case, allowing us to be here today and finally argue our take on the facts and circumstances of what you've heard over the last several days. I want to start with a task that I think we're all inadequate for, and that is I think we have to begin by trying to talk about the unspeakable loss here of young Kaylie Juga. In this case, we know from her friend Jennifer that Kaylie was outgoing, that she was brave, that she was gentle, that she was smart. And we know from hearing and talking about her through others' eyes that at the age we lost her, the world was really waiting for her. We know because we saw Jennifer DeZoma, she'd be a senior. In this chaotic school year that has just happened, she would have suffered through that with all others. She'd be about to graduate. She'd be in that spectacular set of moments where she thinks about jobs and colleges. It was all just about to happen. She was at the very start of those beginning adult chapters of your life at 15, where you think you know everything and don't know a thing, where adulthood looks so clear and yet it is so confusing. She was there. And like the early part of so many of our life stories, she met somebody, right? She met a boy. And sometimes that's the brilliant beginning of life stories. For her, it was the end. For Kaylie Juga, that was the end. Because this defendant took her love and affection, took her bravery and gentleness, and he deliberately and he violently made it so she could never move on. She missed that opportunity, members of the jury, that is so profound, that second relationship in your life. That relationship where you understand, okay, the world has choices. And it's not all or nothing. And the world has all sorts of shades of love and life experience. She never got it because it was all he could do to make sure she would never, ever get there. That second chapter and story was going to be denied her. So I'm going to talk about the evidence in some detail. And you guys have heard it, so you will not hear new information. You'll hear the information we've talked about for several days. And I asked you to think about it with a few different sort of ways to organize it, ways to process what I will be talking about and you have heard. I'm going to ask you to think about this defendant and make some judgments about whether he is a person, one of those people who says, no rules really apply to me. Whether all that you hear and see show he is a person who says, I will not be defined by any of these rules. I ask you also to think about whether he is a person who has a profound ability and degree within him to manipulate others to his purposes. Is he that individual who again and again will use people? Think about all the people who he potentially got in very, very serious circumstances by asking them innocently, without giving them anything but the most selective information, for their sympathy and their kindness, and in taking advantage of that, he achieved her death. And then, we have talked from voir dire through witnesses about domestic violence. And I ask you as jurors to think about this case, though the individuals here are young, within that prism, within that definition of the things we know about domestic violence. Because I'm going to submit to you in this case that the time together between Kaylie Juga and this defendant was defined by domestic violence. And the time apart was the tragic, horrific end of the worst of domestic violence relationships, and that was her violent murder. So as I talk about this case, I'm going to talk about domestic violence and how that defines what happens. I'm going to talk about how a person, the defendant, said, no rule will ever stop me from my obsessions, from my absolute insistence that I have control in this situation. And that no one was someone he didn't feel he could manipulate to his purposes. That end purpose being the death of Kaylie Juga. Because Kaylie Juga was controlled by this defendant, and then he was hurt by this defendant. Kaylie Juga was stalked by this defendant, and then Kaylie Juga was murdered by this defendant. And the Juga family here today is left broken. They're left broken in a house where you can't take a shower alone without that horrific, nightmarish reminder. And where the garage is never, ever, they are broken. So this domestic violence relationship has its beginnings in 2018. And the defendant was again and again welcomed into the Juga home. He's there for movie nights. There's the kind of rules that parents have where you can't have the door closed, and one of you has to be on the floor, one of you on the bed. There are holidays spent together. They fed him numerous times. They spent numerous evenings with this defendant. Their generosity as a family, caused him to know the rooms and the security cameras and the windows that allowed him the information that broke them. And of course there was teen love, but there was also controlling behavior. You heard Stephanie Juga say, you know, there came a point where there were just way too many calls. I couldn't be in the car with my daughter without her endlessly having recalls from him. I had to actually tell him myself, hey, this is a time when she's with me. You need to cut it out. And he would blow it off, but this behavior continued. She would be in her room, and she would always have to have him on the video. They weren't even speaking, but he would always have to be monitoring her activities in her room. So the controlling behavior was even then going on. And by the sophomore year, as this relationship got to its second stage, second part, by sophomore year, you have her friends say, I witnessed in the comments an argument where I saw my friend Kaylie have her ear yanked by the defendant, yanked so she went to the ground. So not just pull, not a joke, hard enough that a teenage girl cannot keep on her feet and goes all the way to the ground. Not controlled by a public place, not worried about detection or being caught. None of those things matter because my control is all that I will be concerned about. I know no limits. My control will not be impacted by the fact I could be seen or disciplined. None of that matters. She will do what I want. And I will hurt her to make that happen. Now, you might say, okay, this is another teenager. You know, what if she has drama in her? What if she, you know, misinterpreted? What if just out of friendship she's, you know, said something that, you know, should we as a jury just adopt what one teenager says and believe it defines what I'm being asked to do today? But you don't have to worry about that, do you? Because you know on January 17th, 2019, less than 4 months before Kaylie Juga is murdered in her home, this defendant is not just witnessed by another teenager, he's witnessed by multiple teachers and an assistant principal. So let's talk about January 17th and whether we know this is a violent, disturbing domestic violence relationship where now, in retrospect, we can see how we got to that horrible day. January 17th, argument. Kaylie Juga just trying to figure out some boundaries, trying to figure out as the victim in these things, what is it that I can do to keep myself safe or in some way take the pressure off me? She asks a teacher to intervene. Not easy for a teenager. She asks the teacher, separate us, please. The defendant will have none of that. You teachers, you don't control me. I'm in my control zone here. You teachers you don't impact me at all. You authority figures, you don't get to decide anything for me. The teacher tries to get him to leave, he won't. All he wants to do is move him to another location in the class. No, that won't be happening. He calls security. Still, knowing security is coming. Absolutely not. I'm in control here. Security are not going to stop me. This is my control zone. Security gets there. They're insistent. That doesn't work. Now, The school police officer has to be called. And now the vice principal is interested. Okay, I got 2 teachers in that room. This is a classroom with 2 teachers. I got security personnel, and they feel they need to bring a cop in. Something must be out of hand. January 17th. The 2 teachers, you heard Mr. Anglin say, I and the other teacher physically tried to get between the defendant and Kaylie. This is an actual physical barrier of adult authority figures. Here is a wonderful snapshot to figure out if we have a defendant who is in any way under control on the issues that we worry about. What does he do? He shoves through teachers because he will be in control in the presence of security. And when he gets to Kaylie, with those teachers present, he is bending her hand. She is crying because he must have her phone. Not his phone, her phone. He has to have her phone. And so I will go through any number of teachers and I will harm her to make sure this is done. Because I am in control. The vice principal gets there. Her immediate instinct is to go to a person who clearly is a victim in this situation. The phone is not recovered until the security cop says there will be consequences, meaning the possibility of some crime. That's what happens when a cop tells you that, unless you give it back. And only then does he fling it. Only then. He's escorted out. School officials try to go different routes to keep people separate, and they accidentally end up in the same area. Here's what you were told by the assistant principal at Bradford. This is the person who supervises the deans. What she does all day is school discipline. So we're not talking about an amateur here. She says the 2 of them end up in the same hallway. There are still law enforcement, school security, a teacher who's coming to do a report, and the vice principal. I'm not sure you couldn't gather in short notice more authority figures in a school at any split second. When the defendant sees Kaylie again, with all those people who should have any rational, under control person understanding, okay, I was out of hand a second ago. I got to get myself together here. I got to be cooperative now because it's not acceptable or normal behavior to again lose it. In that hallway, no teenager tells you this. The assistant principal at Bradford tells you that not only did the police officer warn Martice Fuller, the defendant, don't touch her, don't have any contact with her, but the vice principal says she also told the defendant not to go at her, not to make any new contact with her. Is the defendant in any way under control? Or is his absolute requirement that he control Kaylie Juga so defining of him that he will defy everybody that I just mentioned? Well, we know the answer because he made it through those people and grabbed her backpack, having just been warned not to do that, and said, "You're going to do me that way." This is a young man at that time, this defendant, who has shown us again that he is willing and capable to be dangerous in front of witnesses with consequences coming. None of that matters as long as he gets to be in control. just as that domestic violence mentality tells us is the absolute necessity and requirement of an individual who is an abuser in those situations. So again, he has to be physically separated. And the assistant principal, who does school discipline all day, is really alarmed. When you alarm a person like Jill Schwensen, you're saying something. You are somewhere high on the scales. She called it an extreme case. That's what she told you under oath and testimony. So then, now that incident in terms of the moment of it is over. And Jill Schwensen, the assistant principal, is thinking, how can I give Kaylie some respite and still allow everybody to still, coexist here at my big high school? And one of the things that Kaylie told her, and this is another way control is asserted in a domestic violence relationship, right? She says, I would like to break up with the defendant. This is Kaylie telling Jill Schwensen. But he tells me he will harm himself, and I don't want that to happen to him. So this threat that if you try to take away my control, if you break up with me, I will harm myself. Of course, that's another control mechanism, right? That's saying it will be on you. It's guilting somebody into staying in a relationship with you, another vehicle of control. And it helps define why Kaylie Juga has the impossible choices she has at each moment in this case before she dies. So one of the things that the assistant principal says is, you know what, I'm going to get these people, I'm going to change their classes, all right? I assume that's handbook of school discipline number 1, right? You got 2 people with a conflict, you switch their schedules. I assume that's number 1 in the playbook. It sent the defendant, who was, I believe, serving a suspension, into high volume. You heard the assistant principal. He called every office at the school looking for me. I mean, who does that when they want to talk to the assistant principal? Who won't just leave a message? Who feels they must call every office in a school where a school official says, here's what the guy was doing? It was so insistent. There were so many calls that she, who was at a district meeting in another building, was called by her secretary or somebody working as doing the phones, saying, hey, would you call him? We can't take this anymore here at the building. So she actually leaves a meeting and calls the defendant back. This is a student, because he will not let anyone rest at Bradford because he's about to lose control. And no limits apply to him. More than one call. And so she calls, and what did she tell you about that phone call? He was trying to persuade her. She was telling him, no, this is going to happen. He would stop. The assistant principal had to hang up on him. Yeah. And now, again, a glimpse of who we're dealing with. There is the mother attends with him at Jill Schwensen's office. And this is a meeting to talk about what Jill Schwensen has come to, which is, hey, we're going to have an agreement that allows the defendant to continue his priorities, staying at school, playing football, as long as he does something very simple. He stays away from this person who Jill Schwensen believed was in danger. And what did Jill Swenson, an experienced person who does this every day, what did she tell you? She told you that this was an extreme case of anger. She said, the defendant called me a liar when I reported to him what I myself had seen. I mean, talking about the interaction in the hallway. The defendant is going to tell the assistant dean when she says, here's what I saw, you're lying. He put his finger in my face. The student put the head disciplinary officer at Bradford, he put his finger in her face. She said, based on that interaction, I personally was scared. He has frightened a person who does school discipline all day. The assistant principal is frightened about what anger he shows her sometime after January 17th about the rules or anybody making rules about him and Kaylie Juga. No limits, no control. So, you would think this abeyance agreement is the perfect test, right? Because we assume that the defendant has prioritized, I want to stay in school, I want to play football. So here is our ability to monitor whether he understands that there are rules that apply to him and whether he can follow them. And it only lasts a few weeks. It only, we know the answer to whether he feels any rules apply to him in regards to Kaylie Juga in just a few weeks. All he's supposed to do, evidently he's allowed to see her out of school, okay, because she is minimized for a variety of reasons, we assume, and he is minimized, and so he's being allowed. So it's just about the school day, and yet what happens is in late February, he corners her at a locker. He grabs her. This is after they have already broken up. It's evidently on video. The school people get a chance to see it. And showing he cannot be in compliance, the defendant is now out. Because they have to do what they can to protect Kaylie Juga. Because there's been another time where he showed the rules don't apply to him, and he will do physically whatever he needs to do to get control. And, Kaylie Juga agonized. You could tell that from Stephanie DeZoma and then from her mom's testimony about whether to tell the school about that incident. She agonized, and one of the things she discussed was, isn't this just going to make it matter? If I try to give him consequences or try to draw a line here, essentially the idea is, aren't I in any even more danger? And this is the nightmarish scenario for someone who is a victim in the midst of this type of situation, right? Because if they're going to try to get consequences, if they're going to call somebody on the things they think are dangerous, they have to worry that they'll ramp up the anger. And so they'll be in even more danger. And so, our general and our generic advice, if you and I heard somebody say this, we'd say, yeah, please go tell the authorities, right? But would we be expecting, or would we be preparing for those individuals who are so obsessed with control in a relationship that their ramped up anger will actually be potentially fatal. Because that is what we have with this defendant here today. That's the consequences of the ramped up anger. Because right after that happened, the conversation with the people who we have heard from in this case is Kaylie ruined his life, that Martin Torres said that. Martin Torres said, this is a close friend of his for years. He said he wanted to kill her. Austin Hernandez, yes, he said he blamed her for things. He said that she was responsible and had ruined his life. And from there, from March 1st on, there's the contrast of both of these people's behaviors. Because the pattern of behavior is Kaylie Juga thinking of every strategy she can think of to try to get safe. And in contrast, the defendant spends the next 2 months preparing to hunt and kill Kaylie Juga. What did Kaylie do? Kaylie changed her work. She actually got a different job. It was a heartbreaking letter she sends to Martino's. I mean, for a girl of this age to have to say, thank you so much for my first work opportunity. I don't feel safe. She had the number blocked. This is an open place of business. She got them to agree to keep the doors locked so that customers would have to knock to get in. I mean, they had to change their way they do business to try to keep her safe. She would no longer go anywhere alone. Imagine a 15-year-old. Her life, she's now sentenced because of this ex-relationship. She can't go anywhere alone. She can't, and this is probably the one that I don't understand, but that someone of a different age would, she cannot go someplace with friends and let anybody post or acknowledge where they are. You can't do the selfie that shows the sign on, that you're a great America, et cetera, et cetera. You can't have that life, is what she thought. She joked with people, probably because of the defense mechanism for a human being trying to live every day. She joked with her friends, he's going to kill me. She tried to make it something that could be funny so she could live every day. So she took those steps to try to still be a person living a life and be safe. During those same months, what is the defendant doing? The defendant is getting one guy to give him ammunition for a gun. He is asking someone else to take a picture of him proudly posed with the gun he has obtained. He sends that out to people. Here's my gun. When people see him, he shows them the gun. Would you like to hold it? He takes a bike from the Bowen's household and he stashes it at Ezra Stargell's house, which has the advantage of being a great staging point for your murder because it is directly across the street from the subdivision. So you have a great staging point for whatever is going to come next. He's at Desiree's, where not once, not twice, but 3 times in either communications by media or in person, he says to her, I'm going to kill Kaylie, and he tries to recruit her to help.
And she did nothing. That still floors me.
Desiree, who says he's in a dark jogging suit, the dark jogging suit that he has with him on May 6th, but somehow we can't find now.
Hey, Adair. Good morning. Good to
He's
see
then
you.
at Alexis Fertney's. Alexis Fertney, who's perhaps the perfect person to manipulate. She's the type of person who if you stay at her house a couple nights, she has crutches and she will still go buy you McDonald's for breakfast because you like pancakes. And so she'll still go do that. And heck, she'll give you a ride wherever you want to go. And in fact, if you blow her off in the mid-afternoon, if you make her come all the way across town to pick you up, and she's literally almost pathetically going from parking lot to parking lot thinking maybe he'll be here, and then she drives home, if you contact her again, guess what? She'll drive all the way across town to get you again. So you're with Alexis Fertney, and Lexi, trying to figure out how to stay safe and thinking Lexi Fertney is a friend of hers, is mad because he's at Lexi Fertney's. Here he is again, entangling himself with her life in a way that feels to her like, you know, how am I ever going to get out from under this? And Lexi Fertney and the defendant talk about that when he wakes up in the morning on the 9th. Before noon on the 9th, he's back with Desiree saying, you need to do that to her. I'm so mad. And then the plan is hatched. Then it's the day that this is going to happen. Because he says, drop me at Ezra's. We know they leave at 12:40. We see that on video as they're walking out of the house. We know from 107 to 112, they're at Stein's. Okay, we know that Alexi drops the defendant at Ezra's. Few minutes later, as she's doing her stuff, he says, pick me up in an hour, which conveniently is at 2:40 p.m., which conveniently will be after he knows that
Yes, he's long-winded.
that Kaylie and her mom will be home from school. They get home, remember, typically around 2:20, so it'd be a perfect time for him to be picked up again at Ezra's. He gets over to Ezra's. It's sometime around 2, just before 2. He says to Ezra, just before 2, around then, I'm going to go to my grandma's. Ezra sees him leave on a bike. Ezra's looking out a window, sees him leave on a bike. Just after 2, just into the subdivision, so just literally across the street and a few houses on a bike, seconds after he's left on that bike, we see the defendant riding. We're going to talk about the clothes in a while. And he's headed towards the park. And if he goes on, it'll be towards Kaylie's house. At 2:20, Kaylie and Stephanie return home. And I think we know from the testimony that Kaylie's last good memories are music and dancing and teasing with her mom. And so if we have anything to smile about in this case, it's that those last moments had some joy. Lexi shows up right on time. She is the perfect person to manipulate. At 2:40, she's at Ezra's house, no sign of the defendant. She makes it basically back home before the defendant gets in touch with her, and now he wants to ride right away. And she says, listen, I got to switch cars. I'm driving my mom's car. I got to switch, so I got to get the rest of the way home. And he then begins to call other people for rides. Why? Because if you're over by Ezra's house, as we know from Cole Ballard, the sirens are going nonstop. It's clear that law enforcement who were called at 3:02 are all over the area now. And so this is an individual desperate. The defendant is desperate to be removed from this location. But the only person who will answer him is Lexi, right? So she drives back, she picks him up. It's sometime after that. At 2:56, 50 driveway of the Juga home. He's in all black, but with those same white shoes, he's in all black. It's more than a minute before you hear any shots. So when he walked in, did he try to get a feel for who was there? He knew the cars, but did he try to make sure? Did he head up? Did he savor the moment? Did he have any moments of regret and then got up the courage, bolstered him to do what would get him back in control? We don't know. We know a little more than a minute later, he shoots 7 times. We know that after just 3 minutes and a few seconds, he runs out. He runs out on foot the same direction he came, which is back towards that park, ultimately back towards that doorbell camera that sees him at 3:03, back in a different change of clothes, headed back towards Ezra Stargell's house on that same bike. Stephanie from the diagrams is a couple of doors away from her daughter's room, out closed doors and a hair dry, hair care going, those kind of things. But it's she hears the sound gets through to a shot, can be anything from a firecracker to a car backfire to somebody slamming something in a neighbor's yard.
I'm trying something. Hang on with me.
Scream. Your daughter's scream is not something you have to sort in your brain and your brain subconsciously ignores. So probably after several shots or multiple shots, that scream pierces her. And she heads out and she hears more shots and one. Now, Kaylie is shot 5 times. And you heard the medical examiner say if there had been a team of surgeons at this location. I do want to talk for a moment about the circumstances of her wounds so that we're clear about questions of murder.
Yes.
Heard and saw that there were gunpowder that had burned her arm. At that moment when you would see or first realize that who you have been fearing for months has a gun and it's pointed at you. Whether justice
Trying. I like how YouTube's like, you have an excellent connection, and I know that's a lie. Oh, that's him, Roseanne. That is just him. Absolutely how he goes. He's actually not, he's being pretty calm.
Almost certainly got an arm up and had a bullet go through her arm and into her chest. Where he began Kaylie as well. Did Kaylie begin somehow to try to get her arm in the way so that her arm was closer to the gun and so took the gunpowder? But we know the bullets went into her chest. And I'd submit to you that it is logical for you to believe those chest bullets, probably almost all of them, occur first. Why do I say that? Because there is one shot to the head. If you remember, on her head, there is also a black mark, which appears to be gunpowder burn. So again, that gun is close enough to her head where it burns her skin. It's not just the shot, it's the burning of the gunpowder on her skin. The bullet through her head goes through. It's a through and through shot. There's an entry and an exit wound. And there is a bullet right where her body is, right where she lays, that goes into the floor. So I'd suggest to you the last shot in this case was the defendant. That shot is directly above, shooting Kaylie Juga on the ground and shooting her defenseless and shooting her such that the bullet can go through both parts of her head and into the floor.
Yikes.
And I'd submit to you that when you think about the question of intent in this case, you stop there. I'd suggest your work is done when you consider that wound and how that is really the reasonable explanation for the powder burn, wound to her head, and bullet in the floorboard, meaning it would have to be shot down. And
Hopefully
Stephanie gets
going
there,
better now.
and you heard the 911 tape. And so you know that if there was any consciousness left, when the officer gets there, he says he feels some sort of pulse. But if there's any consciousness left, you know the woman who brought Kaylie Juga into this world did everything she could to bring her back. You heard that. And it could not be done. Even a mother's love could not do it. Because the defendant had acted on his plan and he had done his work. So, in the end, this case finally comes down to what is reasonable. In the end, this case is really about what is all the evidence you've heard, and is there any possibility that this evidence could all be combined so it would have to be faced at jury trial by some man innocent and falsely accused. Now, let me be very clear here. The defense has no burden of proof whatsoever. So I do not mean to make an argument to you today that says they have to prove anything, because that is absolutely not the case. But I'd suggest to you that one of the ways you may look at the evidence is to say, okay, could an innocent person have all of these things happen to them that seem to indicate guilt? And I'd submit to you, in the end, when you consider them all, there's no way an innocent party, a person falsely accused, could have all these things happen. So I'm going to go through those with you, and then I'm going to conclude. So first, on May 9th, Kaylie Juga is killed by someone at 3 p.m. Okay, now remember, this is a scenario where we're considering the defendant might be innocent and falsely accused. At 3 p.m., Kaylie Juga is killed at her home. Okay, and here's a horrible circumstance. If you're innocent, well, yeah, you know her, right? But you know, a lot of people knew her, so that doesn't say anything immediate. But her mom, Stephanie, is also shot. Okay, so if you're innocent, this is something that should immediately clear you, because you know this family. You've been with this family many times over the last year. And so if you are innocent and falsely accused, the fact that Stephanie survived should be the greatest thing that ever happened, because now you will be clear. But instead, here's the horrible circumstance. If you're innocent, Stephanie Juga on 911 is already saying, the person who shot me is the defendant. And not only that, she continues to say it and has said it here in the courtroom. And here's how horrible this is. Here's how unlucky you are if you are falsely accused. This is not a identity from a distance. This is not her having to check and see somebody who shot at them with a sniper rifle. This is someone who she saw face to face in her house and had a conversation with. So this is not a split second where you'd have no opportunity. It's at a distance. Maybe I saw them, maybe not. This is an identification of someone who knows you, where they had plenty of time and close proximity to make the identification. What a horrible set of circumstances if you're innocent. That Stephanie Juga would be that profoundly mistaken, or would choose to frame you and what? Let the real killer go free? Let the person who really killed her daughter go free because she wants to frame you instead? Those are the kind of things you'd have to believe for this to be reasonable, for the defendant to be innocent and it to be reasonable. And now here's a horrible circumstance if you're innocent. You have a motive. You're broken up and you've been expressing anger about that for months with all sorts of people. So of the people that we could find who might have some ill will towards Stephanie, you're at the top of the list. A horrible circumstance. It certainly would make you a suspect, and a horrible circumstance if you are completely innocent. Here's also a horrible circumstance if you're innocent. There are people who are saying prior times you've been violent to her. She's told her friend he punched me in the face. Her friend has witnessed you dragging her down by the ear. There are teachers and staff saw bend her hand in response to her and accept no rules or controls. What a horrible set of circumstances if you're innocent, that you have that track record with the very same girl who was killed randomly on May 9th. It's a rough set of circumstances for you to be an innocent person. But here's another horrible circumstance if you're innocent. There's been prior concerns that the family can even tell us about, and that some of your friends and her friends can tell us about, of you lurking around their house. Remember, the murder happens at the house, right? So who do we have track record of being at the house inappropriately at times they shouldn't when they've been told not to? Oh my goodness, one person, the defendant. So again, this one girl is randomly murdered, and you're the one who multiple people can document have lurked at her house inappropriately before. A horrible circumstance, horrible, unlucky if you are an innocent person. And then this murder is committed with a gun, right? So, again, you're 15. That seems like that would clear you. But, a horrible circumstance. There's all sorts of people who say, during this same time period, you've been trying to get a gun. Well, that's unlucky, right? If you're innocent, you're trying to get a gun at the same time she's murdered with a gun. And here's how horrible that luck gets, okay? Because when we recover a gun, the gun looks like the same gun that you have.
He's so
Because
yelling.
we start hearing from people who took a picture of you with the gun, who when they're showed the gun, they say, yeah, that looks like the same gun.
Probably.
So it appears that by some horrible circumstance, if you're innocent and falsely accused, you have the same type of gun. A gun that looks the same as the gun that is the gun that kills Kaylie Juga. What a horrible coincidence if you're an innocent person. And then here's a horrible coincidence. It's a cousin of yours who takes the police, who otherwise are never going to find this gun, to a sewer in Racine where they find the very gun that is the murder weapon. Okay, so you didn't kill her, but your cousin is able to lead police to the murder weapon, which looks identical to a picture we have of you with the same gun and to what your friend says is the gun you showed him just days before the murder. But why, if you're innocent, would your cousin be able to bring us to the gun? And why would the gun be located very close in proximity to where you are arrested, to by Aunt Shanice's house? That's a horrible coincidence. And in fact, it's even wrapped in a diaper that is an identical size and brand of diaper to the diapers located at Tina Heron's house, which is the first place that you were taking shelter in Racine. So literally, not only is the gun found in the same place that near where you are, not only is it shown to us by your cousin, but it literally it is wrapped in a diaper by the place you were first when you got to Racine. This is a horrible set of combined bad luck for an innocent person who is falsely accused. And not only that, but this cousin who finds the gun for the police in a place they would never have otherwise found it, in a sewer where the grate is on there, right? But when we look at your Facebook records, you, this innocent person, that's exactly the person you were contacting right after the murder to come and help you. So you're innocent. The same guy you've been in touch with immediately to come and help you brings us to the gun. And here's how unlucky you are. Eventually, when your cousin does tell us where the gun is, he also offers to us a gun we would never find otherwise. He says, yes, I was handed this gun by the defendant and asked to get rid of it, and I'm the one who threw it in the sewer. So, let's say you were the cousin and you were just trying to get responsibility off yourself. Would you ever admit you were the one who threw it in there? Never. Why would you ever say I'm the one who threw it in there? Because finally you decided to tell the truth. Just like taking us to a place we would have never found it is showing us you're telling us the truth. And at those moments, those final truth-telling moments, here's how unlucky you are. That's when it's very clear that your cousin, your own cousin, is saying, you, the defendant, are the one who gave us the gun, are the one who gave me the gun, which is the murder weapon. How could this happen to an innocent guy? While I am showing you a gun you would never find, why would I say, you know what? Random randomly, I'm going to show you a gun you would never find, and I'm going to frame my cousin. I'm going to frame my cousin randomly for a murder he didn't do. Who would do this? How could this ever be reasonable? That you would combine showing an undetectable gun and framing somebody else at the same time. And here's how further horrible your luck is if you're an innocent man. Because all of the things I've talked about would have to have already happened to you, right? But then we'd have to find out from Alexis Fertney and from Desiree Flores, from two different sources, that you are mad at Kaylie on the very day that she's murdered.
Me too, because I
You
already.
guys have been broken up for 3 months, 2.5 months. Now we know you're mad at her and expressing that to multiple people on the very same day she's murdered, right around noon. Unlucky
Very long call. How
that this
are
person
you?
randomly murdered, you didn't do it,
Not my
would
favorite.
have that going on.
No, it's not
And
yours either.
you'd have Alexis Fertney saying that she dropped you at Ezra's.
So you guys have heard me talk about Zachariah Anderson, and this is why Zachariah Anderson is why I don't like this Mr. Gravely. His argument in Zachariah Anderson is completely different than this argument here. Lots of maybes. Maybe it happened this way. Maybe it happened this way. Maybe, because it had no evidence. Law Kong Express, go check him out, because he's done a good deep dive into this. He's got some good videos. You need to go check him out. I don't think that the whole trial is up anymore, because I was looking at it the other day on my phone because I wanted to show you guys, but I think they only have clips of it up on Law and Crime and Court TV, but I'll keep looking. So, but I appreciate you stopping by. You've done great work, and you and I feel the same about this man. I assure you.
Which means we can put you at at a apartment that is directly across 104 from Kaylie's subdivision. And here's how unlucky you are. When you were dropped there, sometime around 1:30 or so, when you're dropped there, you're wearing a gray hoodie. And we know this from the Steins video too, but we also, and from Alexis Fertney house video, but we also know it from Ezra Stargel and from Alexis Fertney. So we have 4 sources knowing you're dressed in a gray hoodie, blue jeans, white shoes, and you have a black backpack. Okay? So on a random day, those are the 4 things we know about you, right? Well, here's a horrible, horrible circumstance if you're innocent and falsely accused, because you leave Ezra's right around 2 o'clock, unless Ezra is framing or lying about you. That's what he says, right around 2. And Ezra says he sees you leave on a bike. In fact, he identifies that bike. And here's how unlucky you are. That bike is a bike that Melinda Bowens says you took from her house. So Ezra sees you leave on a bike, which we also can trace to you from Melinda Bowens. It's just at around 2 o'clock. You're on a bike. And then within just a few seconds, here's how unlucky you are. There is video from within the subdivision of an individual wearing a gray hoodie, blue jeans, white shoes, with a black backpack, with a black bike, which the detective has said to you looks to him in close comparison as the same bike on the video. And that bike is headed towards the park. And if you keep going, of course, your route would take you to Kaylie Juga's house as well. So horribly bad luck for you that the only bicyclist through this area is wearing identical outfits down to the backpack and shoes that you are.
You're talking about the microphones?
And riding a bike, which a person like the detective and the other witnesses says is a match to what you left on from Ezra's just minutes or seconds earlier.
Dang, Roseanne.
So that's just right around 2, just after 2. We know that Kaylie and her mom get back at 2:20. That affords you, and this is unlucky if you are a person who is falsely accused here, that time between just after 2 and the time of the entry into the garage, which is about 2:56, gives plenty of time to change, plenty of time to make sure that no one else is home, to wait for the mom and Kaylie to get home. It gives you plenty of time to get up your courage and to get yourself ready to do what you're going to do.
Oh, got it. Sorry.
You do not make the 2:40
I was looking at
preset time
the
that you
microphone.
set with Lexi to come and get you. You are not there for that. That's unlucky, right? Because if you were there at 2:40 as an innocent guy, we'd know you weren't the guy dressed all in black at 2:56. We would know that. But you blew Lexi off at that time. Okay? And then later, as she drives home, after the 3:02, after the murder, then there's this desperate communication, please come and get me in a hurry, hurry up, that happens after the fact. So then here's something unlucky. The person who approaches the house, it's not you because you're innocent, right? The person who approaches the house at 2:56 p.m., do you remember? He actually goes through the neighbor's grass and yard in an apparent effort to avoid the windows, which would be Kaylie's room and the mom's office, and video cameras. Okay?
I can tell you the
Which
time.
you're not good working with. You would know that, right? So the idea is I am hugging an area where I'm not going to be seen, and this person who does the murder is actually willing to walk through someone's yard and grass and jump their fence. Now, let's say that I don't know this house. I don't know what those windows do. I don't know those. I'm not familiar with the fact that they probably have cameras in certain spots. Let's say I haven't scoped this place out. Would I risk walking through the neighbor's yard in their grass and jumping a fence out in the open? I submit to you, here's how unlucky the defendant is. No one would ever do that. If you were thinking, hey, I want to rob somebody in there, I want to burglarize, I have some other motive other than domestic violence, there's no way you would take the chance that somebody would see you walking through a yard, that neighbor could be home. There could be 100 reasons why you bring attention to yourself by doing that. The only reason you walk through the grass in that yard next door and jump the fence of the yard next door is because you're so conscious of how the Juga house is set up that is your priority, to avoid somebody in the Juga house seeing you first or being on any kind of film that the Juga house would have. And again, why is that so unlucky? Because the defendant is a guy who would know that whole layout. A random person would not. And so it's really unlucky that everything about the approach to this house by the murderer is consistent with somebody who knows that house well. That's unlucky for you if you are innocent and falsely accused. You approach from the direction of the
really
park,
hard to sit and
you
listen to
flee back towards the park. The person who does this is wearing a black sweatsuit, right? Black hoodie, black pants. And here's something that's a little unlucky for you. Desiree, who saw you 3 days ago, 2.5 days ago, when you spent the night there, said that's how you were dressed when she saw you last. When she saw you last, that was the outfit you were wearing. And here's something unlucky. We don't find that outfit. And we don't find the white shoes either. Well, let's see. Why, if you're an innocent guy, why would we find you in the clothes that you changed into after and before, and not the clothes you had on when you shed all that blood? Could it be that you're concerned we'll find blood on your white shoes, or you're concerned that there'll be specks of blood or matter on those black clothes, and so you got rid of those just like you thought you got rid of the gun? Really unlucky that clothes that Desiree says for sure he had, that white shoes that multiple people said he had, and that we even see in the video from earlier that day, really unlucky that those things are now mysteriously gone when we take him into custody on the 10th. Those things are all disappeared. Gee, that must be a horrible and unlucky coincidence for an innocent man falsely accused, that the clothes that a murder was done in are the only clothes missing. And the rest of the clothes we've seen him in, we have found. Unlucky if you are falsely accused. So the bike's identical. The clothes that you come to and from after changing in the park appear to be identical to your clothes. And all of those things are just horrible luck for a guy who has motive, a guy who has a gun, a guy who has the same type of gun, a guy who said he wanted to kill her and has all the motive, etc.
So, Law Kong, the only thing, please don't think I'm defending this man, because I am not, because this is really hard for me to sit and listen to, knowing that probably his next trial was Zach's. The mom saw the mom of the 15-year-old that he unalived. He also tried to do the same to her. She actually saw him and had a conversation with him in the hallway of their home where he was, and she lived. So in this case, and I hate to defend Gravely with every ounce of me, he does have she's the eyewitness. She's the victim and the eyewitness. She saw him. So he's just been rambling, really. Because she was there. But every time he says unlucky, falsely accused, it goes through me like you wouldn't believe, because I know what he's going to do. Yeah. He went into their home. He's on video. He went into their home. They were in high school, 15 years old. He assaults her in the school in front of teachers. They're escorting him down to wherever they're taking her to the office. They accidentally cross paths again where he's with security. I'm not, and I don't know by security if that is actual law enforcement officers that, are sometimes at the school resource officers. I'm not sure. That never really has been clear. He grabs her again. They tried to split them up in class, give him this obeyance agreement where he is not allowed to have any contact with her on school grounds. And he can't do it. He ends up getting expelled. He knew that was a consequence of it. Ends up stalking her house out, knowing that her brothers and her dad wasn't home. He then breaks in. Well, he didn't break in because the mom left the garage door open. He then goes to Kaylie's room. 5 times. I'm trying to use the nice words. With the pew 5 times. Mom twice. And the only reason that she survived, he dropped a piece of ammunition. They found that as well. The evidence is there. And it's sad because his life is over. Her life is over. But yeah, no, the mom's testimony was heart-wrenching. He shot, I'm gonna get myself in trouble. One went through her wrist. So she had that. One went through her chest. And she was trying to do CPR on her daughter, who had one to the face. I don't remember where all her was. I don't know if all 5 hit her. She's trying to do CPR on her. 2 nicked her aorta, said she had no chance. 0. And again, it pains me to give this guy anything, and I'm really not giving him any credit because there's been a couple of times where I've noticed he's tried to run this courtroom as well as he did Schrader's. This judge has been really, really good, and she doesn't just let him kind of take over like he likes to try to do. But yeah, this whole situation, when I started watching this, I didn't know it was him. I only saw his assistant do the opening, and she, I hope, got away from him because she's not pulling any of the crap that the blonde on Zachariah's case did. Because that woman is just like him. She could be his daughter. But she's good. She was good. She gave a really good opening, and then it panned over and I saw him and I just was like, oh my gosh. Never even thought about him being there because I don't ever want to. I don't want to watch him. So you're welcome. Again, not defending this man because he's horrible and shady. I wanted my subscribers to see why I don't like him. And this other that they know he yells now. He's not pulled anything. He's not pulled anything in this one. Was the other one? Jessica was her name. I couldn't stand her. She yells just as much as he does. So yes, Roseanne, when a lawyer says 20 minutes, it means an hour. So sorry for that big long pause. We should almost be done because I know there's a break before the defendant starts, and he starts at 3:18. So Gravely should almost be done yelling at us, and Gabrielle does the rebuttal, so we'll at least be able to tolerate her.
Et cetera, everything else I've talked about. So here's another unlucky piece. Alexi Fertney says, after I pick him up, he's in a hurry to get out of Ezra's area there, and he is crying. And by the way, the shoes that I noticed were white before and were clean, now it's been, maybe an hour and a half or so, 2 hours since she's seen him. Now those shoes are muddy. And you heard the detective say that the park, etc., was muddy on that particular day. So somehow he's gotten his shoes muddy at the same time that this incident has occurred, though he's innocent and he's falsely accused. And here's an unlucky part. Alexi Fertney says, you're crying when you're in the vehicle with her. You're not yourself. It causes her to cry. And you tell her a story of a group of girls killing Kaylie. And here's unlucky for you. We know from the video that that's just not it. That's just not true. That is deception from you. So, it's unlucky that Dontrell Seymour ultimately tells us that while he is providing you transportation to Racine, you tell him, I did something, she gone. That's unlucky that you either said that and the explanation that's logical is that you killed Kaylie Juga, or that for some reason he is framing you today. And here's what's really, really crazy unlucky. Desiree Flores Wyrock, not related to you, not one of your cousins, not one of your framing you cousins. Desiree Flores Wyrock, who is friendly enough to you, she'll let you stay at her house and will listen to you when you say things like, I'd like to kill my ex-girlfriend. She reports on May 6th that you asked her to help kill Kaylie and you said you had a gun. She reports, and we showed evidence that on May 7th at 6:54 p.m., you sent her a text, and we know it's him because it's consistent with what he told her the night before. Do that hit with me 100%. And then just hours before the murder, Desiree Flores Wyrock confirms, and we have evidence that a text or that communication was made at 11:52 a.m. saying, I'm so mad, you need to do that to her. So if you are innocent and you're falsely accused, why is this random person, Desiree Flores Wyrock, who I believe my co-counsel artfully said, if you're getting some kind of deal, how come you keep getting charged again and again and again with new charges, right? So it's the worst. You know, there is no evidence there's any deal. In fact, there appears to be the contrary. And she, in custody, came here and told you this person, who she identified, wanted her 3 separate times, the 6th, the 7th, and the day of the murder, the 9th of May, to help kill Kaylie Juga. If you're innocent and falsely accused, then you are also a person who is also trying to have her killed that day, and yet you are not responsible for her death. That's how unlucky you would have to be. And then a couple weeks before, you get Kyle Bowen to give you some ammunition for this gun that looks the same. And you're given the wrong bullets. Okay, it's .380 ammunition, 9mm pistol. And the ammunition that Kyle Bowen gives you has a very particular stamp on it, right? It's a particular a brand, and so it has its own stamp. Here's how unlucky you are. You got some of that ammunition from Kyle Bowen, and it's wrong for the gun, so that's weird, okay, that coincidence is true, because the murder is, again, also a crime that occurs where someone is using a 9mm, we know because there's a murder weapon, and they're using .380 ammunition. So the mismatched ammunition is the same circumstance you yourself have in the gun you have, even though you didn't do this, okay? That's how crazy it would have to be for this to be an innocent man. But remember, though, too, even more particularly, here's how your bad luck would be. The stamp on that ammunition from the Bowen household is the same as the bullet that's found, apparently dropped on the sidewalk by the park, where logically you would hide your bike and you would change your clothes. Okay? So a person engaging the gun or doing something with the gun might drop one of those bullets. And again, it's that same type of ammunition. And in Kaylie's room is another one of those spent casings with that same Kyle Bowen's brand ammunition. I mean, what are the chances? What are the chances that you did not do this and that it's reasonable that these things would occur? Okay, now, I haven't even gotten to the most powerful piece of evidence in this case, guys. I haven't even gotten to the part that simply could not happen in any conceivable way consistent with the defendant's innocence. Because Anshanice Andrews is done with her interview. She is literally being escorted out of the interview. And a detective says to her, what if your daughter was in the situation Kyle was in? What if you were Juga family? And she stops the detective and says, I have more to tell you. This is the defendant's cousin, who in that moment of conscience, right? In that moment, thinking about the Juga family and the loss, said, I have more I can tell you. He confessed to me. And then, as you've heard us a couple times say, but I'm going to cover one more time, there are a number of things Ann Shanice knows about this case, that many of which the police do not even know yet. Okay? Here's what that would mean. If Ann Shanice is able, in the very early morning hours on May 10th, to provide the information, the defendant, my cousin, confessed to this crime with these details,
Oops.
then she has superhuman psychic ability. Okay? She can predict the circumstances of a murder before they are known to the general public, before they are even known to the police. And that superpower that she possesses, for some reason, if this is an innocent man, she uses that superpower on this day to try to frame her cousin for a murder. A person who no one's identified that she had anything against. That is what you would have to believe. Because Ann Shanice Andrews says that the defendant told her that that Kaylie, the victim, was mad at Lexi, where the place he was staying, on that morning. Well, how would they know that? I mean, no one had talked to Alexis Fertney fully yet. The law enforcement would not know that. Certainly that was not out there in any fashion in social media that she would have any access to. And Shanice said that the defendant, her cousin, said he was dropped by a friend who was driving him around. Well, how would she possibly know that? How would she possibly know that that's how the mode of transportation? And Shanice Andrews said he biked into a park. No one knew that yet. No one had reviewed this video at the time Ann Shanice was being talked to. So there's no evidence in this record that anyone knew that except the defendant at the time of the incident, at the time Ann Shanice shared that information. She said, he told me he went into a park and he changed into dark clothes and he had white shoes. Well, that's exactly right. That's exactly what we know after we look and compare the videos. And how, under any circumstances, would she know that? The law enforcement did not have any idea of that yet. She predicts actual true facts before the police have any idea. And Shanice said that he jumped the fence. And again, that we know that from the video, but that video had not been reviewed or in any way looked at, and certainly wasn't available on social media at the time Ann Shanice Andrews gave that detail. She indicated that he said Kaylie was playing music in her room. And no one knew that until Stephanie Juga was spoken to at the hospital after that. There's no way that anyone would know a detail like Kaylie was listening to music in her room, which Stephanie confirms at that moment. How would you know that detail without psychic abilities or having heard it from the defendant? He said that her mom was in the other room, that he shot her mom twice. That wasn't publicly known. No one knew how many times she'd been shot. How would that be something Ann Shanice Andrews would know unless the defendant told her? How could she get that right? And then she was shot when the mom opened the door and then she tried to close it. Well, that's exactly what Stephanie tells us. But Stephanie had not even been able to go through that version with us because she was still in the hospital under critical care, and there was no way the detectives involved with Ann Shanice knew those details yet. She said the defendant told her he shot Kaylie in the face and something about that there was a black on her face. And that's the one that sent chills through me. Because you heard Stephanie say that, you heard that first officer, Deputy Eckert, say there was black mark on her face. How would Ann Shanice Andrews know that? Unless the defendant had said it as an observation himself. He texted a friend to pick him up. That's exactly what happened. How was that available to Ann Shanice at that point? And then here's the other one that sent the chill through me. He told the mom of a friend, "Don't tell the police I was there." that's not the kind of detail anyone had. Easily accessible at that point. That's not something that was in social media. It's not in writings about the case. But when you heard from Alicia Stargell, okay, the mom of a friend, she says, he told me, if anyone comes, don't tell him I was here. So again, how would Anshanice know that? So I'm almost done.
Liar.
All of those things from Anshanice Andrews could not be known, could not be accurate and right. Even the police didn't know them, many of them, at the time they first spoke to her, unless the defendant had told her, that those had occurred. And so for her to make those things up and be right and be framing him is beyond any reasonable belief. It is not a reasonable basis for doubt. Now, the last piece I want to talk about in terms of that is this interview with Detective Dietz. So, the state put that in. We said, here's what he told a guy who we knew from coaching, because Detective Dietz works for KPD, but he also, coaches at Bradford, so he had some interaction and relationship with the defendant already. And what happened in that interview from the state's perspective also is something you should consider, and goes to this idea of how if this was an innocent man, these things just wouldn't happen. Okay, all of these things would not happen to an innocent man. So why do I say that? Because what the defendant offered to Detective Dietz was this. Essentially, I did not kill Kaylie Juga. Instead, here's what I did. I was over at Lexi's. I got up around noon. I had some pancakes that she brought me. I walked from there to my mom's house. I got to my mom's house. My mom had a baby over. My mom and I interacted. And then I decided to go take a nap. And so I napped till sometime 2:45, 3, at which point I began to walk some paths at Parkside. And that's my explanation for my whereabouts. I was by myself walking the paths at Parkside. Let's think about that moment. If you are an innocent man falsely accused, well, here's your moment. You know Kaylie Juga is dead. You know you're not being talked to at random. So if you are an innocent man, what you would do is you would say absolute truths. Because this is that moment, right? This is the moment for absolute truths if you're an innocent man falsely accused. If you're guilty, though, you're going to lie. Okay? You can't tell the truth, so you're going to lie. And you're going to tell lies in hope that they can't be proven. Okay? And here's what you know. You know that what he chose to do was tell lies. You have the video. You saw a snapshot at Steins. You have the testimony of both of the Stargells. They're making this up. The Stargells are lying about what happened at their house on 2 parts of that early afternoon. When he says he was at his mother's house or at Parkside, he was at the Stargells' house. Lexi Fertney, who says I gave him rides during the times he says that she wasn't with him and that he was at his mother's house. Okay? So all of those individuals, and then you have Cole Ballard, right, who says I spoke to him on the phone at 3:20 during the time that, according to what he told Detective Dietz, he'd be at Parkside by himself on some park path or on a bench. And Cole Ballard says, I spoke to the defendant by phone. I know him. He's a friend of mine. I know his voice. And he wanted me to come and pick him up at Aurora, which is right by Kaylie's house, right? So we know from Cole Ballard, who otherwise, what, is he going to frame people? Is Cole Ballard a part of some huge frame up here? that isn't, that what he chose to tell Detective Deeds is a pack of complete and utter lies. And again, if you are an innocent man and falsely accused, it is horrifically bad luck that you chose that moment to lie your rear off about where you were. Really bad luck. Then I just want to talk for a split second about tampering with the jury the last time, because again, that goes to consciousness of guilt. Okay, an innocent person does not feel that they need to again try to manipulate every friend and relative they can think of. You know, possibly getting these people in trouble, right? Telling them, hey, get in touch with this person. I can't say much. They're recording the calls. You know, don't make me talk about it. But, you know, do you remember what I said? Do this, you know, so forth. All of this sort of manipulative direction of those people still trying to stick around and stick by him is what you do if you are guilty and you simply are doing everything you can think of to avoid responsibility. Ladies and gentlemen, when you think about all those things together, you will conclude there's no way all that stuff could happen to a person who is innocent and falsely accused. The only reasonable explanation is the defendant is guilty of the offenses we have considered here today. The defendant killed Kaylie Juga. He entered that house with a gun. He tried to kill Stephanie Juga. He took away so many things that we have grieved over in this room over the last several days. He stole them away. He stole them away because of his absolute need to be in control of situations. Your verdict today will take that control back and will tell this defendant, it is about the rule of law. He doesn't get to control. You, the jury, do. And so I ask you to find him guilty and hold him responsible for those heinous crimes that he has done. Thank you.
I think we're done. Oh my gosh. Lord.
Jury, how you doing? Do you need a break to use the restroom or anything before we start the next argument? Okay, we'll do that. We'll just take a quick run down, and we'll be, as soon as they're ready to come back.
Don't give them the option to run, Judge, because they may just run away after that. All right, so he started at 1:34:15 and ended at 3:03 minutes. So what? Hour and a half? Is that right? I'm not good at math. If Brand's listening and I'm wrong, be like, that's embarrassing, Mom. Well, you didn't get your math brain from me, Brandon. No secret. All right, it's the little Boy Scout's turn now. They'll try to dig out of this. There's just nothing to dig with. That's the unfortunate part. Yeah. Roseanne knows the outcome now.
This is a difficult case. There's no doubt about it. It's a sad situation. It's a tragic situation. But your job is not to decide that. Your job is to look at the evidence and to decide whether the state has proven its case beyond a reasonable doubt. In a little while, the judge is going to give you a jury instruction. And what that instruction says is that the time has come now when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors. Selected for this important duty, you will not be swayed by sympathy, prejudice, or passion. You'll be very careful and deliberate in weighing the evidence. It's a really important job. But when you look at the state's case, you're going to see that there's some holes. And they have the job, they have the burden to prove their case to you beyond a reasonable doubt. Even as we sit here right now, Mr. Fuller still has the presumption of innocence, and he maintains that presumption of innocence until the state proves otherwise, until you decide otherwise. So let's talk a little bit about reasonable doubt. There's not anything that says it's, a certain number that says, oh, I've got to get to, I'm 90% sure, or I'm 85% sure.
When she's a victim.
But I like to think of it as the big decisions that we make in our life. So when we buy a house, when we decide if we're going to marry someone, if we're going to have children with someone, even buying a car. And a reasonable doubt is a doubt for which we can give a reason. So I like that car, but every time I touch the brakes, it's something squeaking. It's making me nervous. I've got a reasonable doubt about buying this car. That house was perfect. Everything looked great. Home inspector thinks the roof needs to be replaced. Not sure I want to buy that one. So those doubts that kind of keep you up at night, they keep you thinking. And you start analyzing it and thinking about it, but those are the ones that you just can't get rid of.
Yeah.
So I want to give you a little bit of a roadmap of where I'm going to go.
I don't know.
And I'm going to try hard to stick to that roadmap. First, I want to talk to you about what's missing. Clothing, DNA, fingerprints. I want to talk to you about some of the witness testimony that you've heard over the course of this last week. Talk about the timeline that the state has presented to you. And then to talk about the physical evidence. So let's talk about what's missing. And it's no secret that the black sweatsuit and the white shoes are missing. The police think, and the state has said, they think that Martice changed his clothes, put on a black sweatsuit, and entered the Juga home. Don't have the sweatsuit. And it's not for lack of trying. We know that they searched 4 different places that they think that Martice had a connection to. They looked in Horizon Park. They looked around Ezra's house. Detective Kennedy said, we were looking for them. We were looking hard for those clothes. We don't have them. And they don't have them to be able to test for DNA, to figure out if there's an initial on the tag that says Martice or MF. There's nothing there to be able to have those clothes to see, are these the clothes that we can see in that video? And do they belong to Martice Fuller? And there's not witnesses who say, I saw some kid changing his clothes somewhere in that park by my house. That's something that's going to draw attention. People are going to notice if someone is doing that. The police check the wet park. They don't find bike tire marks. And apparently the ground was wet enough, the state says, to have mud on shoes, but not for a bike to leave marks.
Yeah.
You heard from an analyst from the state crime lab, Ms. Fisher, about DNA, and she told you, here's why I don't think there's DNA on this gun. She also said, though, that was all I had. I was asked to look at swabs from a gun, that was it. Not swabs from the door handle between the garage and the inside of the Juga home. Not the stair railing. Not anywhere else in the home to try and figure out, was someone in there and who they were, someone that didn't belong. Stephanie Juga on the 911 call said it was Martice Fuller. Police took that and they ran. They didn't try and figure out, can we get some physical evidence such as DNA, such as fingerprints, just to be sure that that's right. But they heard that name, they got tunnel vision, and off we went.
And I would agree with him on a lot of things.
So let's talk about the witnesses.
not in this.
Stephanie Juga testified in this case. She was going through terrible things on that day. I cannot even imagine. But I also know that when I'm going through unimaginable things and scared and frantic and panicked, I'm not at my best. And you can hear it in her voice on that 911 call. She's not sure of how old she is. And she is just distracted and panicked. And understandably so, but that's the reality of the mental state at that time. And the judge told you when thinking about when someone identifies another person, she gave you a kind of a list of things that you should consider. And one of them is the mental state of that person. And so think about how scared, how panicked, and how distracted Stephanie was when she made that identification. And certainly at the time that she made that identification, there was a lot that had kind of led up to it. Martice Fuller was not high on anyone's list at that house, that's for sure. So he would be an easy person to assume that that's who it is. And I want to be clear, I'm not saying that that Stephanie Juga came up with this sinister plan, but when you think of where she was at that point in those moments, there's every reason to believe that she's mistaken. And we've all, I'm sure, been in situations where we've been panicked, where we've been fearful. And we all know that that is not the time when we are at our best, when we're making good decisions. And we know that our memory can be affected by that. There was also talk about cameras. And the state has gone to lengths to talk about this person in the black that kind of hug along the house. And the state says that's because it was Martice Fuller. Martice Fuller knew that there were cameras. He knew where the bedroom and the office were. And so he wanted to be close to that house. However, we also heard testimony that there are cameras inside of the Juga house. Now, they're not always working. But we also know that they get moved around at times by Nick Juga. So if you're someone who knows the house, you know kind of what goes on in the house, and you know enough to know there's cameras on the outside, and you know other things according to the state, you're taking a big risk by going to this home with cameras on the inside. You're taking a big risk that as soon as you walk in that door from the garage, there's not going to be a camera pointed right at your face. We also know that Stephanie Juga's description of how many shots that she heard is not the same as how many casings are found within the home. And again, I think it's evidence of where she was in that moment, and that her memory is off and it's inaccurate about what happened. And you may feel a lot of sympathy and empathy for Stephanie Juga, and that is completely fine and that is completely natural. I think that's probably the only human response that we could have. But I'm talking about her memory in those moments and the reasons to doubt her memory. So the judge is going to tell you, as I said, that your job is to evaluate the evidence, to look at the evidence, but to not be swayed by sympathy, prejudice, or passion. And so that's what I want you to do when you think about that testimony and think about the identification that was made. We also heard from Martin Torres. And Martin Torres, we know, had Martice Fuller's Facebook account up on his phone for about a month or so. And at a time when he wasn't seeing Martice. And so he had complete access to that phone. Now, Martin Torres says, I never used it, which is not surprising. But he had every ability to do that. He had complete access to that account and the ability to impersonate Martice Fuller. We know from Alexis Furtney, who is The state says the first person to see Martice Fuller after they say he committed murder, she doesn't see a gun, she doesn't see any blood, she doesn't see a black sweatsuit. There was Dontrell Seymour. And I will say this, that I appreciate that Dontrell was willing to kind of own it. Because he said, I lied, and I lied over and over and over. I felt like they were coming after me, and his first instinct was to lie. You heard his testimony. You heard him admit that he lied. He's not credible at all. You heard from Ann Shanice Andrews. And the important piece of Ann Shanice Andrews is that she says, I was not close with Martice. I wasn't close with his family, his father. He didn't come around family. But she says and expects us to believe that this person who was sort of a semi-estranged cousin has basically just emptied their soul to her, has told her everything, confessed to murder to her. It just doesn't make sense. Jennifer DeZoma testified.
Mine too. Makes my head hurt.
And she talked about some incidents at Bradford High School that she says that she witnessed, that were around other people, that were in areas where there also, in addition to students, there would have been staff, there would have been security cameras. And she says nobody does anything. She says Martice Fuller yanks on Kaylie Juga's ear. Nobody does anything. Nobody intervenes. He punches her in the nose and causes bleeding. Nobody does anything. Nobody says anything. Nobody notices that her nose is bleeding. It just doesn't make any sense. And I understand this is a hard situation for her. Jennifer DeZoma is dealing with issues that are well beyond what some teenagers should have to deal with. But it doesn't add up what she says she observed and what she says happened.
Me too.
A student assaults someone in the middle of a school and causes bleeding, and nobody notices.
Again, they're teenagers.
The state also had Brian Martinez testify from Martino's Dry Cleaning. And he says there's these phone calls, they block these phone calls. You have seen no evidence of phone records from Martino's. You've had nobody say, at least from law enforcement, nobody has said, okay, the number that called Martino's was this number. We know that this number is Martice Fuller's, and this is how we know that. You didn't hear any of that. And you heard a bunch of witnesses say Martice didn't have a phone or a phone that functions as a phone. He had Wi-Fi. Desiree Flores Wyrock, she's got her own problems right now. She made some additions to her statement after she had been charged with crimes and after she was meeting with the DA's office, the same one that was prosecuting her and is prosecuting her again. And she understands the predicament that she's in. She understands that this district attorney's office has a lot of power and a lot of leverage over her, and she better make them happy. And so she has every reason to do or say the things that are going.
Yep.
And so through this investigation, the police have received information that was not completely true, was not completely reliable. And sort of the bad inputs make bad output. So if I have a soup that I'm making, I put all these ingredients in, but I got some in there that are rotten or no good, that affects the whole thing. That affects the entirety of it. And so that's what the state's presented to you. They presented you this case with certain things that don't make sense and that impacts the entirety of that case and should cause you to have doubts about it. So let's talk about the timeline. And
Please don't go
I
into
think
what we
that
are.
the purpose of readdressing that issue this morning was to try and make it less confusing. I came out of it more confused. But basically what the state's theory is that there is someone who rides through the Horizon subdivision and goes past 109, 19, 69th Street, and they're going westbound at that time towards the park. Now, yesterday, Detective Kennedy said when we were watching the video that didn't have a timestamp, he said that happens at approximately 2 o'clock, that an individual with a gray sweatshirt and jeans is riding westbound. Now the state is saying, no, it wasn't really 2 o'clock. When we put it on this different player, it shows a different time. It shows later than that, closer to 2:08, 2:10. And so the timeline shifts depending on what media player it's on. But you know what we saw yesterday. We saw a video from 109, 19, 69th Street. And Detective Kennedy said there's a person going westbound. On the timer for that player, it happens at 35 seconds. On cross-examination, I said, can you please move it up to 54 minutes and 37 seconds? And there's a person going eastbound. We're not playing a trick on you. That you saw it, okay? But the state puts it on a different player, uses a different computer, and everything gets kind of confusing. And so the point of that is I think there's reasons to be very skeptical about a timeline, because the things that the state, well, Detective Kennedy said approximately 2 o'clock, then it changed. We have this new player. The new player changes around kind of what we see as far as time goes, and then what that means for the state's timeline. And so things are not as clear as the state wants you to believe on their timeline. What the state believes happened is they're saying that Mr. Fuller goes into the home, shoots Kaylie Juga, shoots Stephanie Juga, comes out at 3 o'clock, runs westbound, finds someplace where nobody is going to notice, changes clothes, gets on a bike, and then they have him at 109, 19, 69th Street, they say at 3:03. That's not a lot of time to do all those things. And Detective Kennedy said, well, I think it would take this long to ride a bike to here, or to run from here, and to get to this place, to that place. But ultimately, it's your choice, and it's your decision. You don't have to take the testimony of Detective Kennedy, just as you don't have to agree with or take as true the testimony of any witness. It's up to you to decide for yourself. And then let's talk about the physical evidence. Yesterday, Detective Kennedy looked at the video. He showed you the video. He said, I can't tell the gender of the person in that video outside of the Juga home. I can't tell the race of that person. Now, he does say that he can see blonde tips on dreadlocks of someone riding a bike on the video from 109, 19, 69th Street. Again, you get to decide that. Okay, my eyes are not the greatest, but I can't see it, okay? If I got my contacts in, I'm not that far away, I can't see it. You get to decide whether you can, okay?
Well, because that video.
But I don't think it's there. And so again, you get to decide, is the person who I see on this bicycle and the person who goes into the Juga house, is that the same person? And there were some comparisons they did. It's your decision, okay? Because Detective Kennedy says, well, when I compare this, I compare that. You don't have to listen to him if you don't want to. You get to decide. You also heard Officer Valeri testify about ejection patterns and different things at the crime scene. And what I just want to highlight is that when she comes to the scene, she knows what she sees when she gets there. She doesn't know how things get to their final landing place. We've got a projectile on the stairs. We've got a casing down on the first floor. So she can say that's where they are when I see them or when I recover them, but she has no idea the story of how they got there, how they traveled there. And let's talk about the tool marks. So I think the first thing that's important to highlight is that there's an assumption that kind of overarches tool mark examination, and that is that every gun leaves distinctive markings. So although there may be thousands of the same type of gun, same manufacturer, same caliber, and even maybe manufactured one after another, that each one of them would leave a unique and distinctive marking that this examiner can identify on a small object, on a projectile or on a casing. And that there's going to be, that each one of those would leave that unique and distinctive marking. So we talked about what's the standard or what's the evaluation that happens. And so the examiner looks at this object on the left, looks at this object on the right through a high-powered microscope, but they're looking at the two things. And it's up to them to decide what I see here looks the same as what I see here, or it looks similar enough that I think that there is sufficient agreement. So the tool mark examiner, Ms. Williams, she said it's a match. That's not exactly what the standard is. The standard is, does she believe there's sufficient agreement between this one and that one? And sufficient agreement, if you remember, has this long and confusing definition. That is, when it exceeds the best agreement demonstrated between tool marks known to have been produced by different tools and is consistent with the agreement demonstrated by tool marks known to have been produced by the same tool. So when she says match, that's not what it is. She's saying there's sufficient agreement when I look at this thing on this side and this thing on this side, and I've examined them with my own eyeballs, and that's the decision that I've made. It relies an awful lot on her. It relies on the fallibility of humans, of us as people. The state has described what it says is stalking behavior. You have not received an instruction about making a decision about whether Mr. Fuller stalked Kaylie Juga. He is not charged with that offense.
I say I might have to fight him on this one.
It's a diversion. It's to gain sympathy and appeal to your fear in this case. Your decision is to look at the three charges that Mr. Fuller is charged with and decide whether the state has met its burden beyond a reasonable doubt for those three charges. It is not to decide whether he was engaged in this stalking type behavior or this domestic violence behavior that the state says that he did.
I would have never been allowed to serve on this jury anyway because of.
So as I said when I started, there's some big holes in the state's case. There's those lingering doubts and questions. What about the clothes? What about the timeline? Was Stephanie Juga's memory able to take in this information? Was she able to be accurate in her reporting under the stress, panic, and fear that she was under? Can we trust what the witnesses have told us? Do we trust the things that the state has presented for their timeline? All of those things. So those things are here. And those are doubts. They create the doubts in this case, those reasonable doubts. So again, it's the state's burden. It's their job to prove their case to you beyond a reasonable doubt. And they haven't done that. So we ask you to return verdicts of not guilty. Thank you.
So there's a lot of what
Thank-
he said that not in this case, but in a different one, I would 100% agree with him on. He brought up a lot of really good points. They just don't fit here because we have her mom, plus everybody else that he dragged into this, plus the witnesses at school, plus her boss. I mean, there's just too much. In a different trial, all those arguments that he brought up would be really good. Did they prove this? And it'd be great for them to have to ask themselves that. It's just not here. I hope, it's just not here. All right.
Thank you, Mr. Johnson. State's rebuttal.
She does not take long. Just like him, she's not that long. It's like about 30 minutes. Give or take. Not going to yell at us, I don't think. Always a plus.
There are no holes in the state's case. We told you in the very beginning that any case is putting pieces of a puzzle together. No one person knows the whole story except Martice Fuller. So what we do is we take testimony from each person who was manipulated and used and abused by Martice Fuller. And from there we follow those threads to the whole story, to the truth, to see where it leads. Attorney Johnson said the jury instruction will tell you you must reach a just and fair verdict. And what is just and fair is a guilty verdict in this case. The jury instruction also tells you you are to search for the truth. You are not to search for doubt. And a reasonable doubt is not a doubt based on guesswork or speculation. And that's what you have been asked to do right now. To guess and speculate and disregard the overwhelming evidence that you have been presented with. The identification of Martice Fuller by Kaylie Juga is without doubt accurate. She had this person in her home over the span of 10 months for hours at a time, talking to him face to face, listening to his voice, looking at his face. She told you she relives what happened every day. She sees it in her mind every day. Despite her efforts to diminish those memories, those horrific memories, by putting up photos of Kaylie throughout the house, she will never forget. There are some memories that are burned into your brain forever. She sees his face. She hears his voice. She sees the gun being leveled at her chest every day. She hears his words when she says, "You don't have to do this." Yes, I do. There's no confusion about this. She tells the 911 operator on multiple occasions that it is Martice Fuller, her daughter's ex-boyfriend, who shot her and is in her home. She knows and tells the 911 dispatcher his mother is Alice Fuller. She tells the dispatcher he's mixed race. He's half Hispanic, half Black. She gives them their address. She says, we are 4 blocks away from Aurora Hospital. There is no confusion in her brain, in her mind, or in her memory. Yes, she's frightened. She doesn't know what's going to happen to her or what has happened to her daughter. But that moment in that hallway where she sees Martice Fuller is something that she has no doubt about and will never forget. Perhaps what Attorney Johnson has asked you to do would make sense if we had only one of those witnesses and not all the others. Well, disregard Ezra Stargell, disregard Dontrell Seymour, except you have all of them. You know, Attorney Gravely told you how impossible it would be for you to be not guilty with each of this evidence all presented together. He knew when they would be home. He knew their schedule. And you know what? Shanice Andrews, when she testified, she told you that. She said, Martice told me that he knew when they would be home alone. He watched them. He watched Stephanie and Kaylie Juga go into their home that day. How would Shanice Andrews know this? What reason does Shanice Andrews have to make this up? She may not be close to Martice Fuller, but do you really want to falsely accuse someone of first-degree homicide and attempted first-degree homicide if they have not confessed to you? This is no false confession. This is no false accusation. She knows what she knows because Martice told her. Attorney Johnson asked you to look at what's missing in our case. We're missing the black clothes. We're missing the white shoes. That the police did a very thorough search to find it. They looked around Ezra's house. They looked around Horizons Park. They searched a few homes. Yes, they did. They did try their level best. But you know what? You know what would have been missing if not for Dontrell Seymour? The gun. We only found the gun, the police only found the gun because Dontrell Seymour led them to it. In a sewer in Racine County. I wonder where the idea to drop something into a sewer came from. How many sewers are between Kenosha, Horizon Subdivision, and Racine where the black clothes and the white shoes could have been dropped? Why else would Martice Fuller get rid of his white Nike Huaraches? Why haven't they been found if they were not deliberately hidden, concealed to prevent law enforcement from finding the evidence that Mr. Johnson wants us to, or faults us for not finding? Attorney Johnson said they don't even submit the DNA from the house, from the door handle, from the stair railing, because the police were so focused on Martice Fuller. Well, you know what? Even Martice Fuller told Alexis Fertney that he's concerned he'll be blamed for this shooting of Kaylie Juga because his DNA is all over the house. He's been there so many times. You don't need to look for someone else's DNA when you have an eyewitness identification that is conclusive and all the other facts lead you to the same person. He wants you to not believe Dontrell because Dontrell lied. And Dontrell admitted that he lied. But what you cannot disregard is Dontrell led you to a gun. And it was wrapped in a diaper that matches the diapers found at one of the relatives' homes. Do you think Dontrell just decides to not only falsely accuse his cousin, the person that he's just helped, knowing that there is a manhunt in place, but he leads the police to some other gun? Or maybe he's planted the gun so after helping his cousin, he can then turn the tables and falsely accuse him of this murder? That makes no sense. But that's what you would have to believe to buy into Attorney Johnson's theory. Don't forget that this whole family, the defendant's entire family, knows that he has killed 2 people. That's what they believe. Martice Fuller went to the grandparents' house and everyone starts scurrying to take action to protect him. When Aunt Shanice Andrews drives by, they all want her to come be a part of this. Martice Fuller just killed 2 people. That's what the family tells. The family that just saw this defendant at their house. Attorney Johnson talked about Jennifer DeZoma, that none of what she says can be believed because no one intervened. Jennifer DeZoma told you what goes on in the commons area during the breaks. There's a lot of commotion. You get all those high school kids and all their raging hormones and they're released from a class. No one's paying attention to one another. They're in their own teenage world. So yes, no one saw what Martice Fuller did to Kaylie Juga that day. And no one saw what he did when he punched her in the classroom and caused her nose to bleed. Unfortunately, there are not staff members in every classroom at every moment of every day. And you can only look back on the cameras for the surveillance if you are told something may have happened. Someone's not manning those cameras all day long looking for something that might be going on. That's just common sense. That would require a team of security. He also wants you to not believe Desiree Flores. Desiree Flores, he says, has her own problems. And that is true. Desiree Flores does have her own problems. But that's not what led her to add to her statement after her charges. Desiree Flores adds one thing to her statement after her charges. What she told the police originally is that Martice asked her to kill his ex-girlfriend, that the girlfriend was a bitch and he could just kill her. No, for real, I want to kill her. That he had a gun to do it, that his friends touched the bullets, so he was going to use those bullets. And that he asked her 2 more times to do it. So the change is that when she spoke to the police, she said, Martice told me he wanted to do it because Kaylie and her mom put him in jail too many times. When the truth of the matter was that he was just angry and hated Kaylie because he had been suspended from school and he could not play football and he was not going to be able to go forward with this football career. That's the only change.
It's a little more than
that does not really gain her much advantage. It gains her no advantage. And in fact, you heard her testify. Did you get any benefit from this, Desiree? No, I didn't. Did the state promise you anything? No, I didn't. No one did. And Desiree, after you told us that he hated Kaylie and her mom because of being suspended from school, did we, the DA's office, keep charging you with crimes? And yeah, did you see her shake her head? She's like, yeah, you keep charging me, even though, I have given you this information. And then she sat up there and she swore to tell the truth, and she did. She told you the truth, even knowing that we keep charging her, even though she has given us this information. She didn't have to do that. Mr. Johnson says, well, there's doubt because there's not a lot of time to do the things that we saw on video. There's not a lot of time to leave the Juga house, change your clothes, get on the bike, and then ride past. Except really there is plenty of time. You saw Martice Fuller sprinting from the Juga house after the shots are fired. It's about 30 seconds to sprint from the Juga house to that tree line. He was wearing a tracksuit, a warm-up suit. This is what Desiree Flores saw him in a few days earlier. Tracksuits are designed to be pulled off quickly, to be worn over other clothes. That's why they're warm-up suits. He did that. Doesn't take very long to rip off a sweatshirt and rip off your pants, especially if you're not changing your shoes. And he didn't change his shoes. And then it would take another 30 to 40 seconds to ride fast on a bike between that park tree line and the Nest doorbell camera that we saw. What is that? 2 minutes then? According to the video, we have 3 minutes. He's got a minute to spare. So yes, it is logical, it is reasonable, and it does fit with the timeline. There's nothing confusing about it. And there was nothing confusing about that video. Detective Kennedy told you he watched it through and through. You saw the clock this time. The clock says no one rides past at 2:54. It happened at 3:03. The tool marks, you listened to that expert testify, and she is an expert. She talked about her years of experience, the thousands of cases she has worked on. This is a science, and it is accepted across the world. She listed her training. This isn't something we just created because we want to convict people. This is a science. Just like comparing fingerprints, it uses trained experience, education, and eyesight to know what to look for. And what we know is that the gun that Dontrell Seymour leads us to in the sewer is a match to the bullets that were found, the bullets in the casings that were found in the Juga residence, in Kaylie Juga's body, and in Stephanie Juga's body. You can count on that. That is not reasonable doubt. That's wishful thinking, but not reasonable doubt. So when you go back in a few minutes to deliberate, I'm asking you, don't engage in this wishful thinking, in this fantasy that Mr. Johnson would like to create in this case. We have facts, and every witness who testified, there is physical evidence to back up everything that they told us. And you saw it. You saw it on video. You saw it In audio, you saw the guns, you saw the casings, you saw the bullets, you saw the bike. So do one thing that Attorney Johnson told you to do. Return a just and fair verdict. And again, I will tell you, the only just and fair verdict in this case is guilty on all 3 counts. Thank you.
Thank you. Ms. Scheidegger, Mr. Johnson, Mr. Gravely. Ms. Gabrielle, thank you. Now, members of the jury, the duties of counsel in the court have.
Alrighty, so they're going to go back and deliberate. Let me put my. Even she was loud. So they're going to go back and deliberate now. And they do come out and have a question. So I'll go to that. I never know when the judge.
Oh, you ready? Okay.
Howie. There she is.
Okay.
I agree. She's way better. And yell at you.
Okay, we're on the record. There's a question or a request from the jury. The jury is requesting that the audio video of the shooting, the video from across the street, I'm assuming they mean when the sound of the guns are made. So you'll need your video man.
Uh-oh. I hope he's better. Hope he's better than he was this morning.
Yeah, there's no other way to do it. It's just, we're not sending something back, right? So we just let them. Okay, so
He's kind of dumb sometimes.
we'll let him get set up before we do anything else.
Wonder if he's going to tell us again that that's his guy and the state was so nice to provide him and let us use him, and they shared.
Okay,
There he is.
they are requesting the audio video of the shooting, video from across the street. So you get yourself set up. Then what I want is I want them to.
She's like, I need to mute my mic. What's he doing? What are you doing, Gravely? You weirdo. Other than trying to run the courtroom like he usually does. Yes. Stop doing that. If you have that power, make my internet stop screwing up. I don't know what the deal is today. I'm going to go fight it. Take it out of the closet. Beat it up. I still like this judge. I still think she did a good job. I still want her to travel the land and tell all other courtrooms how to do their audio. And just record her voice telling people to get the microphone. Get on a microphone. Except I noticed she didn't tell Gravely to get back to the mic when he was yelling at us from across the room. She's like, okay, my ears are bleeding too. Yeah, she's done good. She's done very good. Well, she's done well. Excuse me. My Indiana grammar. Yes, her little tiny hands and her little tiny size. She could be the defense attorney's mom. Just kidding. She's like, you tried, son. You had nothing to work with. Don't worry, those weren't jurors. she's been very careful. And she told them, she reassured the jurors that they had not been shown and that they had gone to great lengths to make sure that they did not show their faces at all. And she did a really good job. Miss Gabrielle's gonna go tell Wish William how to do the sound in case he forgot. I thought I had this right on the time, but I guess I didn't. My apologies. I had to write that time down for some reason. I also thought Gravely was going to say something again.
Okay, so on the record, what, we're playing from what to what? Talk loud so she can hear you next to you. The record.
He couldn't hear you because he had to stop talking.
State's Exhibit 76, file number CAM4 underscore 05-09 underscore 2019 underscore 15-33 -30 underscore 15 space 59-59 underscore.
Sorry.
And it's going to start at 3:56 and 20 seconds.
Even the judge was amused by that for some
Okay.
reason. I don't know why it was funny.
And essentially go until the figure runs from the house.
I think we're going to go till it.
They'll go to the end of this file, which the figure running from the house is
On the end of it.
immediately following this one.
Say that. Say I didn't hear you.
Separate file.
It's the running from the house is separate.
Correct.
Okay.
So what are they asking for?
They asked for the jury requests the audio and video of the shooting, video from across the street.
So does that,
I will ask them when they come in.
Gravely wants them running from the house.
Okay, they can bring their books and pencils with them.
And Your Honor,
Yes.
I'm sorry, I don't know, is the state requesting that they be told that it's off an hour? I think that's.
If they be told what?
The state had just said something about the time being off an hour. I guess my belief is we should, clarify with them what they want to see.
We'll show them what they want
And no explanation.
and no explanation, but they might want the next video.
Right, if they request that, I think we should
I'll
play
ask
that
them,
for
is
them.
that what you wanted? And then we'll see what happens.
I wonder if Gravely was getting a little nervous because they actually had a question. He's got his hand up there getting ready to hit the button on that microphone. All right, come on, people.
Let's let them get in here first. I think they're going to come in my new side doorway, but I don't know for sure.
Elf door. Where are they?
You have the other one queued up too, Brian?
Oh,
You
I
have the
love
second one queued up? So you will have to do anything to it?
She's like, "Are you sure?
Okay,
I don't want the issues we had earlier.
thank you.
We've been doing so well." Are they not in there yet? Don't know what that look was. Like, where are they? I can't tell if she's watching them walk in.
She's distributing.
She's like, why is she taking so long, really, is what she wants to know. Absolutely. That mom voice that came out of her earlier today was like, okay, don't yell at me. See her yell at Gravely. Not that she's had any reason to, but if she would have had the Zachary Anderson trial, things probably would have been a lot different. She wouldn't have put up with this crap. Good grief. I don't know why I paused this so far back. Me too. I just don't. I think her chuckles are about to run out, though. It's like, how long does it take to distribute their notebooks? Now she's writing a note. Reminder, pass out notebooks quicker. This is insane. There we go. I think a lot of grandmas do because they've been like, I've seen it all. Don't try to pull anything on me. I've been around for a long time.
Okay, please be seated. It's my understanding you asked for the audio video of the shooting, video from across the street. We're going to show you one. If that's not the one you're requesting, because there is continuation. So if this isn't what you're asking me to show you, please raise your hand and say, we want whatever you want. Okay? So go ahead, Brian. Thank you.
Sorry. That's bad. It's bad, I know. But that's all I know of it. All right, remember this has a lot of wind. For those of you who haven't seen any of that,
Was that the part you wanted?
I
Or
always
did you want
five, but
the
I never
next
hear
part
the
also?
two.
So, yeah, I see some yeses. Yeses, tell me. Tell me. We're good? Okay. Okay. Okay, thank you. Bye.
Get out. I did not. I did not. I'm honestly, I don't look for any of her stuff. It doesn't surprise me. Uh, Again, no excuse for what she did, but obviously her house growing up was not great, and she continued the cycle instead of stopping the cycle. So it doesn't surprise me at all. Well, then that definitely doesn't surprise me. I mean, if she was worth that much money, they didn't have anything, it doesn't sound like. Yeah, it doesn't surprise me. Are you saying that in Griffin's voice? What? I can't do it, obviously. All right. You guys ready for the verdict? So they deliberated for about 3 hours. They were obviously, like I said, they took, I mean, they at least they took it seriously. They at least asked questions. I don't know what they wanted with that one because, like I said, I can hear the 5 to her, but I can't hear the 2 to the mom because the wind. You're already- I must have been in another world yesterday when I wrote down these timestamps.
Yes. Okay, so ladies and gentlemen, there's a verdict, and we're going to read that verdict when it gets in here, okay? There is to be absolutely no emotional response to the verdict, no matter what it is, by anybody in this room. It's important that that not happen. We know everybody is tense, but there is to be no response whatsoever, and if there is, they'll be ejected from the room. The court has to carry on some other duties that we have at that time, so I want no disturbance. The jury will leave. We will take care of some other business. Everyone else will stay in here. And then I will have the complaining witness victim family leave first. The Fuller family will stay here and have an opportunity to talk to Mr. Johnson and Ms. Scheidegger, okay? So that's how we'll do it. And I hope that you can all comply with that.
Same thing.
Okay.
I wonder if that was his
Yep.
family that they just showed. Also, I mean, they didn't put on a defense. Not that they have to, because they do not. Just, I don't know. Like his parents are just have me confused. Yeah.
How much help do you need getting stuff put away? You got it?
A good egg or a bad egg? All righty, here we go. Also, I didn't realize that the judge had somebody else sitting on the other side of her. Till they just showed it, whoever that woman is. Probably her clerk.
Okay, please be seated. Has the jury reached a verdict?
Yeah.
Would you give the verdicts to the bailiff, please? Notes are in there too, right? Okay, great, great.
See anybody there that looks old enough to be his mother? Not that can't be deceiving, but they looked young.
The verdicts read as follows. We, the jury, find the defendant guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 19th day of March, signed by the foreperson. Did the defendant commit the crime while possessing a dangerous weapon? The answer is yes, dated and signed also. As to count 2, we, the jury, find the defendant guilty of attempted first-degree intentional homicide as charged in count 2 of the information, dated today and signed by the foreperson. The question is, did the defendant commit the crime while possessing a dangerous weapon? The answer is yes, dated and signed by the foreperson. The verdict for count 3 is we, the jury, find the defendant guilty of armed burglary as charged in count 3 of the information. Is there a motion to poll the jury?
Yes.
Okay, I'm going to start in the back far corner, and you don't have to stand up, but I'm going to say to you, as to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict? Next, as to count 1, was this and is this your verdict? As to count 2, was this and is this your verdict? As to count 3, was this and is this your verdict?
I was just looking at him. I think I saw a little emotion come from him. Probably shock. I don't have any idea what his sentence is. I have that. We can watch that next. He was a minor at the time, and the Supreme Court passed that law that you couldn't sentence minors to life. So I'm not sure. I know I heard enough when I was trying to see how long Gravely yelled at us again. I heard him ask for life, but I don't know what he got. Maybe that's his mom on the end there with the glasses. But no matter what, if he got 10 years, 20 years, 50 years, 100 years, as young as he is, if he goes into, and I don't know again, because how old he is now, well, I didn't want to go to Comic-Con anyway, Roseanne. He will not come out rehabilitated after being in prison, going in that young. I don't believe that will happen for him if he gets parole at all. Oops. I was really just curious to see who went over to talk to him, but I don't know if they showed. I didn't watch. No football. Oh, I got you now, Roseanne. I was like, what the heck? Are you pulling a Gabby? No, he's not safe for the community now. No football. No nothing. I mean, it's over.
Mr. Gravely.
Your Honor, I would move for judgment upon the verdict, and also pursuant to the verdicts, we would move for a revocation of bond. Would ask for a date for sentencing.
Mr. Johnson?
We move for judgment notwithstanding the verdict.
Court is going to enter judgment on the verdict, subject to any post-conviction motions. The bond is revoked, and we will get a date for sentencing. Did you ask Heidi by any chance? Okay, we'll get to that.
To set a date for the sentencing had certain family members. Now that the trial is concluded, we'd ask that that order be vacated so he'd be allowed to have contact with his family.
Counsel, I think that the other case still has a no contact order.
I'll lift it on this one at this time.
Sure.
However, if the other one continues it,
Yeah.
he's got to abide by that until something else happens.
I just want to be sure we're clear. I think the other one still has a no contact order, but okay.
I didn't know there was another
Say
one.
May 19th at 1 o'clock. Does that sound okay? Or 1:15 probably?
You'll be busy that day, Martice.
Wait a minute.
May 19th at
Did you,
1
does Heidi
o'clock.
say that's good? Oh, okay. Well, I don't think that's right. I think I've got a post-conviction motion that day. Oh, really? I don't have.
I don't know, Gabby. I don't know what the other one is.
Which is supposed
I'll have
go
to look.
Monday from the morning on. Do you see anything that says-
Because they did the mom and the daughter in this one. I have no idea. I'm too scared to touch anything because of my stuff being stupid. Yeah, I was confused too. I don't know.
I'm sorry, the 19th at 1 does not work.
That does not work?
No.
Can we consider that Friday, the 21st? I have a trial that starts that Monday, but then by Friday afternoon, I'd be available.
Okay, Friday, May 21st, does that work?
Is that all right?
Should we do it in the afternoon? Will we need more than an afternoon?
No, I think an afternoon would be fine, but if the court is ready to do it at, say, 1:30, so that
Okay, so,
I have an opportunity to finish my trial.
okay, 1:30,
That's fine.
May 21st. Thank you very much. Thank you so much for all the work that everybody put in.
One more time, May 21st at 1:30.
Yes, sir. Okay, now, I'm going to excuse, no, I'm not.
Even though I can't see his mouth, which makes it hard to read emotions, he's showing a look more than he has this entire time. That guy, asked you guys earlier, what was he going? What was he trying to do? What did he think was going to happen? And the problem is he couldn't because of he's too young to think it through and the permanency of it all. The lady sitting at the end of the row that has the woman with the pink hair and the woman with the long purple hair. She has glasses on. She has her mask pulled down. I wonder if that's his mom. Oh, yeah. She never gets to do anything. I don't know what he was trying to think. Like, I don't know what he was thinking. There's some emotion. Now he's getting it. Yeah, you're done. It's not the end of it. I feel sorry for all of you. How did things get that way? So many people ignored so many things in that, or just didn't do anything, or didn't take it seriously enough. There's so many things that were done wrong, handled wrong. Hindsight's always 20/20. I mean, just the simple fact he would. I don't disagree with that, Roseanne. He needs a lot of help, but it's help that, and I'm not saying, so it's not that I think that he doesn't deserve prison time, because he certainly does. It's not going to, if he can be fixed, it's not going to happen there. He'll come out worse because he's so young. All right, well, we're not in the gymnasium anymore. We're in the actual courtroom. It's very full. And I'm really, no battle of the bands. I'm really curious. I will have to go back and look when he said he had a trial starting. I can't remember. I don't think it was May when Zachary Anderson's trial started, because I think it was still a little bit cold outside because they were still wearing sweatshirts there. All right. Prepare to get yelled at by Gravely for a little bit again. Sorry.
No food or drink allowed in the courtroom. No use of your cell phones or any electronic recording devices. If any are seen, deputies are told to take them. After the hearing is concluded, just please wait in your seat until you're dismissed by the deputy. All rise.
I'm trying to move the captions. But legally, Roseanne, I don't know if they can. We'll see, because of that Supreme Court ruling of you can't sentence a minor to life in prison. And I didn't hear anything about him being
Invited to speak or is going to speak. They'll be allowed to take their mask off also, okay? So I'll call State of Wisconsin versus Martice Fuller.
Your Honor, state appears by Mike Gravely and Angelina Gabrielle of the Kenosha District Attorney's Office.
Martice Fuller appears in person with Carl Johnson and Jillian Scheidegger.
This matter comes on for sentencing. I have reviewed all of the letters that were submitted by family and friends of the victims and of the defendant. I've reviewed the sentencing memorandum and the pre-sentence that was filed by the Department of Corrections. As to those items, Mr. Johnson or Ms. Scheidegger, are there any factual errors in the pre-sentence?
No additions or corrections.
Mr. Gravely?
Same for the state. We're ready to proceed.
Okay, go ahead.
State would ask that Stephanie Juga have an opportunity to speak to the court first.
Ms. Juga, come on up.
So I think that's the mom, the dad, the brothers sitting right behind the state. Or the police guy just sat down.
All the time you need.
Can you hear me?
I can.
Okay. 2 years ago today was the last time that I saw my daughter, Kaylie. Today, 2 years ago, the day her father and I had to lay Kaylie down for her final resting place. She was only 15 years old, with so many dreams and goals that she had. She was such a kind-hearted person. She could light up a room and could always bring a smile to anyone's face. Martice Fuller ruined it all. He ruined all Kaylie's dreams and goals that she had. Martice Fuller killed my daughter on May 9, 2019, in her own home, and then attempted to kill me with no second thoughts or regrets. During the trial, he sat in the courtroom with no remorse for our family or our daughter, Kaylie. Not only did he kill Kaylie and try to kill me, he took so much more away from us. My daughter's gone. That means no more's with her. We don't get to see her graduate high school this year. We don't get to see her go to college. We don't get to see her get married or adopt children like she wanted to. Kaylie will never get a chance to meet her new nephew. She would have been so excited to meet him and the best auntie ever. We just simply have no mores with her. Our life is forever changed. Our house is so different and so empty. Our home is where we are supposed to feel the safest, and Martice Fuller ruined that and took that safe place away from Kaylie and myself. Martice Fuller didn't only take our daughter's life away, but he ruined me. I am not the same person anymore, and I never will be. My best friend is gone forever. We did everything together. Whether we were shopping, going to the gym, going to Starbucks, watching Netflix, jamming in the car to music, or just dancing like crazy in the kitchen. She was always by my side, and she was my biggest cheerleader. Now I'm lost. I just feel so lost without her. I don't like to go anywhere or socialize with people. I just feel lost. Not only emotionally am I changed, but I also am physically. I deal with daily pain in my wrist where Martice Fuller shot me. I am limited to what I can do. I can't open certain things, lift heavy objects like I used to. I can only hold my grandson for a very short period of time. I also had to stop working so much because of the pain in my wrist and the numbness that I have on the top of my hand that goes down my 2 fingers. I also have pain in my chest where the other bullet traveled through my body. And the doctors say that this pain may never go away due to nerve damage. So not only am I living with a broken heart from losing Kaylie, I also have a daily reminder of the pain that I have to go through of what Martice Fuller did to Kaylie and myself on that day. I have nightmares all the time and flashbacks that take my breath away and make me have panic attacks. This not only affects me daily, but it also affects my husband and my 2 sons. My husband has to replay the call that I called him that day, screaming to him that he was to come home right away because Kaylie and I had been shot. He couldn't really understand what I was saying, so he had to look up on the police scanner to see what actually happened. Having to rush to the hospital to take that to hear that Kaylie didn't make it, seeing me in the hospital bed waiting to have my first surgery, my husband having to tell me that Kaylie, our daughter, didn't make it. I know this is what he thinks about all the time, and it weighs very heavy on his heart. My oldest son, Tyler, calling me in a panic, asking me where I was, then watching his mom covered in blood being put into the back of an ambulance. My youngest son, Mason, getting picked up from school by a police officer, not knowing what's going on, and the police officer can't tell him. Getting brought to the ER, seeing his dad and his brothers just stand there. He asked what's going on. Hearing that his mom and his sister were both shot by Martice Fuller. Then the doctor walks in to tell them that Kaylie didn't make it. My husband and 2 sons had to hear the worst news ever, and now they struggle with the pain of losing their daughter and their sister for us. Sons don't get to make any more memories with their sister. The struggle we have is real. We all struggle daily from the loss of Kaylie. I feel that Martice Fuller should get life with no parole, as I feel that he will not change, and he may do the same to another person. If you can enter someone's home and walk to their room with a gun and shoot them several times, and then turn to their mom and try to kill her as well, and then also deny everything and put the family through 2 years of going through pain, makes us go through 1 week of the trial, reliving that day all week long, was absolute torture for us. Having to see all those photos on that day, and then having to see our daughter's autopsy pictures. All while Martice Fuller sits there with no remorse for Kaylie, myself, or my family. Then you regret nothing, and I feel that he would do it again. If he was able to get out, I would be scared. He would want to come find me, and I feel that he would try to finish the job. Please, Judge, feel my pain.
Thank you, Mrs. Juga. I appreciate you speaking. Does
Thank you.
anyone else in your family want to say anything at this time? Not right now? Okay. Okay, Mr. Gravely.
Your Honor, the recommendation of the state could not be made more strongly. The court watched the entire trial. The court saw the emotions and passions of how this case was approached by everyone from law enforcement to the prosecution to the family and community supporters of the victims. We are collectively asking you as the sentencing judge today to impose a sentence where this defendant, Martice Fuller, never again is released from custody. So we are asking on the homicide to Kaylie that you impose life and that the defendant have no possibility of extended supervision. We're asking that counts 2 and 3, the attempted murder of Stephanie, and 3, the entry into this home, which should be their sanctuary, should have consecutive sentences as the court feels is appropriate. But in all situations, we ask the court structure a sentence where the Juga family will never again have to fear that this defendant will be released during their or their children's lifetimes. And I do that understanding the magnitude of asking this court to impose that sentence on an individual who has recently turned 18. But I on behalf of the state, cannot more strongly express to the court that there are some losses that are so enormous, there are some crimes so terrifying to the community. There are some moments in a courtroom where other elements that I have mentioned must be at the forefront of a court when they impose a sentence. And I want to first talk about the enormous loss here. And I am conscious I do little justice to it based on the letters, the heartbreakingly eloquent letters the court has from Nick Juga and other family members and supporters, as well as the loss so well expressed by Stephanie today. But I want to remind the court of the moments in our trial where those who care for Kaylie Juga talked about her as outgoing and brave and gentle and smart. You heard her qualities. You know that her whole future was stolen, was taken in a moment of controlling rage. The kind of controlling rage this court has seen hundreds of times. And so the court can quantify it. The court can organize how dangerous the controlling rage in this domestic violence case is. It can decide, is this at the highest levels of the danger of those kind of aspects of character that the court saw expressed by this conduct. Kaylie died at 15, and so much, as expressed very eloquently, will be missed. And, you know, one of the true tragedies of this case, of course, is that Kaylie thought she could heal whatever rage was in this man. She believed she could fix him. She wanted to save him. And so there is that double tragedy, and it is a quality that you don't need to know this family for long to know that is throughout the Juga family, that they are about healing and saving and protecting people, including those who are damaged. And so, you know, Kaylie taking that brilliant characteristic, that characteristic that we all want for the most promising young people in this community. And it was her death. In this tragedy, it was her death. What you know about her in death is that Kaylie can be finally summarized as the kind of young woman that everybody who wrote you wants to claim credit for. They all want to claim credit for the fabulous things she was. And it cannot do anything but break your heart to hear Stephanie Juga speak today, as it did on the witness stand, because she is still devastated in the ways she talked about, with the physical injuries that have basically ended her ability to do her profession. And then how heartbreaking is it to know there's a new life in this family? You know, an opportunity that brand new life could be a place she could heal. You know, that moments of the love of a grandmother could be a place where she could find some healing point. And her physical limitations even limit her ability to bond there. You know, the pre-sentence says she can't hold that child for an extended period of time. So even there's a reminder in that moment that might be a brilliant new beginning for her. She has to be reminded. And this letter that the court hears about briefly in this case that is received by her from the jail, where an inmate knows intimate details about their life. An inmate writes a letter, and it is not per se a threatening letter, but it is a letter that knows their cars and the inside of their house and her profession and their home. And it's a person that no one in their family knows. And upon police investigation, what is revealed is that it is a person who shares a cell. This is post-arrest. This is an individual arrested for murder and held in custody who shares those details, and that individual indicates he was urged by the defendant to write this letter, which cannot come out of thin air. Further terrorizing the woman you couldn't kill. What defect of humanity and character allows you that decision-making from a jail cell? It is the absolute necessary demand in everything about his being to be in complete and utter control. Definitely went along a murder charge. And he's causing devastatingly personal letters to come from the jail because he needs the upper hand. He needs the controlling thing at all costs. The letters describe the same Stephanie you see, a person who has parts of her that feel dead inside. You know, the biology of the world says, you know, your child should never die first. And that's because parts of you die then. And she feels guilt to feel any joy. You know what? Where do you go next? And I want to suggest something simple to this court. There is no ability for Stephanie Juga to heal until this defendant is in prison forever. That is the only place where she is going to be able to find any place to start a recovery. And I believe that is a reason that the court should consider today. I have to tell the court I cried openly when I read Nick Juga's letter. I did that because this is a man who has spent his entire professional life protecting this country and protecting all of us as individuals. He has put himself in harm's way in remote and secret and ugly places again and again for us. And now he's a man, his whole life has been protecting people. How will he ever be able to recover from the people he loves most dying and being under that threat in his own home? This is what he is about. This is who he is as a human being. So you couldn't harm or corrupt everything he has stood for more profoundly. You couldn't poison the well of his life more profoundly than to go to his home, a man who has protected Martice Fuller and his family by putting his life on the line again and again. The Juga home, Your Honor, is a tomb. Their home is a graveyard of memories. Many times a day, they have to pass a room untouched for 2 years because they want, in every bit of their being, to have a day or a way that the occupant will come back to them in some way or form. And so they cannot process or be a part of that everyday door that is a reminder for them. I need to tell the court a story about the Jugas, which I think must be told to this court so that you know who the Jugas are in terms of character of people in this community, because this goes to their loss. Miss Gabrielle and Miss Beasy and I went to their home. This was a couple weeks after this homicide. So these are folks whose grief is as raw as it could be. We went to their home to begin the long process of preparing this case. And I can speak for myself. I think I can speak for my colleagues. When we entered their home, the scene of all this tragedy, we were overcome. We couldn't function. It was that devastating. Do you know who comforted us? The Juga family comforted us. We're bystanders being comforted by the people who have suffered. That's the strength of character of the people you have suffering in your courtroom today. That's what they're capable of. I don't know if it's the military family background or the tradition of service or the just needing to make everybody as healed, who's broken as possible. But I mean, it is almost unexpressible, the character of someone who can make that happen. Now, I've talked about this crime on its level to this family. And that is something that should never be not at the forefront here. But I think it's important to talk about the devastation that this crime had on this community as well. Because it's not every day that we're in here talking about a crime that literally terrified the entire community. I want to bring us back to that day. This is one of those rare crimes where the knowledge of it passes mouth to mouth, where people are being called desperately at their workplaces or at their homes, where the texts get there quicker than the media does, where everybody hears gunman is on the loose and here's the neighborhood, and they're immediately calculating, am I or the people I love in danger right now? The schools in Kenosha locked down. They would not let their children out because they have that duty to protect in those moments. Everyone called and texted their children and told them, as I did, and told them, do not leave the house, lock the doors. That's what we all did because of this crime. That's the category of crime the court has before it today. At their own home, in the middle of a weekday afternoon, when they are doing everything right, she picks up her child from school. They're getting ready to go camping. It is a everyday Kenosha day. And this devastation occurs. And why it is so terrifying to the community is there's no strategy to keep yourself safe. You cannot keep your teenager from falling in love. You can't keep your teenager from trying to heal people. You can't not invite people into your home. There's no way to keep safe from someone who is willing to be a predator in this regard. And that's what is so terrifying and devastating to this community. And so the nature of this case could not be more serious. And I want to talk for a minute about the injuries too, because I think they go directly to this defendant's character. Kaylie is shot 5 times. 4 of them are to the chest. 1 is to the head, and he even mentions to a family member that her face is blackened after he shoots her. And what that is, Judge, is stippling. And stippling means you have shot someone at close quarters, in the face. Not in the back of the head, Judge, in the face. He could look her in her dying eyes and had to be close enough to her to blacken her skin in that moment with the soot of the gunpowder. That's the character of this man before you today. He's capable of that. He's capable of that moment. And I think the defining moment of this case, and let me say first, Stephanie Juga is alive today for pure, unadulterated, beautiful fortune. If she had seen him first, she easily could be dead. If she had come a second sooner, she could easily be dead. If she had made it 3 or 4 more steps further from that door she could close, she could be dead. If there were not 2 doors she could close and the last one lock, she could be dead. All of those things are just the sweet, random fortune that has her alive today. Because this defendant was clearly ready, willing, prepared to shoot her multiple times and did so in areas that could easily have caused her death. And I think a defining moment in this case is when Stephanie tells us she faces him and she says, "You don't have to do this." And he very clearly tells us what he's about. "Yes, I have to." And I think that defines this case. It shows that the domestic violence that is throughout this case has the hold that is willing to cause a death, willing to cause multiple deaths if necessary. He has to be in control, Judge. Kaylie can't fix him. She can't help him. Having a situation where he's in a crowded hallway doesn't stop him. Teachers don't stop him from needing to be in control. Police officers assigned to the schools cannot stop him. Contracts with the school saying you will lose all the things you care about at school and sports cannot stop him. His own parents warning him, trying to tell him, you cannot be, you've got to let this girl go. You've got to do something else. Cannot stop him. And then Kaylie's parents cannot stop him. Nothing there can stop him. Remember the moment in this case where the dean of students of the high school he attends tells you, Your Honor, she was frightened. Frightened. This is a person who does discipline all day as her job of students, of high school students. She is frightened by the anger and lies he directed at her regarding Kaylie. Now, the defense has indicated in their documents, and I think they're going to say in their argument, you got to give a release date because he needs hope. The way he's going to improve, the way he's going to become a different person is by giving him some hope today, Judge. And I would suggest to you that strategy has been tried and has failed, and we know that because of the death of this young girl. And so everybody tried that. Everybody said, we'll give you hope. Just correct your behavior. We'll sign a contract with you. We'll just warn you. You know, there's a lot to lose. Get better, do better. And none of it ever worked. And so it would be naive and dangerous to go with that strategy again. And if you needed any more convincing, facing a trial, look at his jail conduct. With multiple incidences of violence, with uncontrollable behavior, knowing he would face a sentencing court. We know that before the trial even, with hope out there for him, that doesn't control his behavior in any way. And then I want to talk about the jury tampering. I don't know. I mean, I've been at this a long time. So have you, Your Honor, on the bench. I've never seen a more profound attempt to manipulate people to try to tamper with the jury in my long career. And it is, again, a show that this strategy of offering him hope will not keep us safe. Because then, when he should have had those moments of hope, he's about trying to corrupt the system profoundly. And that, again, is a crime against the Jugas. Because it delays this case, it doesn't let them heal for even longer, and it tries to make it so they will never get an opportunity for the facts to be decided and responsibility to be given. So I suggest to the court, if you think about how planned out this incident is, I know, Judge, I'm talking in some detail, but I just want to be clear how much we are in a situation where this is a premeditated crime. He plans out this incident days in advance, maybe months in advance. He carries out a reconnaissance mission a few days earlier using the same bike, going to the same location. He refers to it in texts that we show to the jury as a hit. And that's exactly how he plans and conducts this case, as almost a professional hit. He has an original staging point at the Star Gel's house where he takes a bike and stashes it days earlier. He rides to his second staging place, which is a wooded area just a couple of blocks from the Jugas. So he has reconnaissanced 2 places where he will be able to be anonymous. He rides in both directions to both of those 2 staging points. He obtains a gun from one source and ammunition from another, so that you only have to tell a certain amount of information to those you're manipulating. He does change his clothes. He spends days trying to recruit a helper who is essentially, he's telling her, be my assassin. I mean, that's what he's doing. Do this hit for me. And she refuses, but that is going on for multiple days, including the day of this murder. The schedule is no accident. He has a narrow band of time when he knows none of the Juga men will be home. He knows that Kaylie will have gotten home from school, and he knows exactly who will be home. There's no surprise or accident, Judge, that this happens at exactly the time it happens. And if you look at how he maneuvers around and sachets up against an area that would be a risk to avoid cameras, you know that he has thought about this in ways most of us would never even have considered. He has thought it through in all those ways. He asked someone new to get rid of the weapon from him, someone uninvolved in the rest of it. He has a false alibi that he presents to the cops. And is it an accident that his mom separately provides exactly the same false alibi? I don't think so. I don't think those things happen in a vacuum. And his mom then, when she is pressed and confronted with some of the details, admits, I'm lying about this. That alibi is a false alibi. But they tried to do that before, and that had to have been considered either before this incident or at least right after this incident, before he moves to Racine. And then the family assists him in getting out of town. So who does he manipulate? And again, I ask the court to think about the profound criminal thinking involved here. The Stargell family, Desiree, Dontrell, the Bowens family, his own mother and father, Martin, his close friend, Ann Shanice, and Lexi. All of these people individually
have been manipulated by giving them selective information so that they have a part in this heinous set of crimes and his escape. Also, he can be in complete control. He's one of those rare individuals willing to kill to maintain control. So I want to talk a little bit about some of his family and supporters, a little bit in the pre-sentence and out on the internet, and what I want to describe to the court is really an alternative false reality. Okay, so there are members of the family or supporters who have indicated, well, this is a bunch of misunderstanding and some lies have been told about this innocent guy, and we don't, he's not capable of this, and all those kind of things. And I need the court to understand that some of that information, at least in the pre-sentence, is provided by his mother, who I don't expect to give up her love for him just because of conduct here. I understand that is going to happen. But her information must be interpreted knowing she deliberately gave a false alibi as her first glimpse in this case. And so that must be the context of every single thing she says. She says that they didn't actually kick him out of the house. Well, we have an abundance of social media evidence of texts which show that he wouldn't follow their rules, that he was lying about them regarding times they tried to enforce rules, and so they told him to get out of the house. And then he went to his grandparents and would not follow his grandparents' rules, and so then lied to all the people in the community who then harbored him, telling him that he was unwelcome at any place. In fact, he just refused to follow the rules at every place that was welcoming him and wanted to be in places where no one would provide those kind of rules and supervision. Why? Well, possibly because he had a murder to commit. But even if that's not the case, if he's just wayward in many of those moments, this is a false narrative. And the family, to the extent that they have said, he's innocent and all that, it needs to be said today in front of this large crowd. There are texts from a sibling of the defendant to teachers in real time. There's no reason that sibling would lie. And she is describing the family situation where her brother has told her parents this horrible crime. And they are scrambling and saying, we need to have him see everybody once before he turns himself in. So this narrative from family members saying, oh, we don't know if he did this or he's innocent. It is one of his own siblings texting teachers that shows how much of a false narrative that is. There is a narrative out there by the mother that, he just had a gun, judge, because family members were in danger because of something that happened in Racine. Well, not only is there none of that in the social media, but here's what her texts say in real time. She is warning the Juga family, hey, I'm hearing rumors my son has a gun. Watch out. Call the cops if this happens. So she is, rather than justifying in any way in those days, she is thinking that the Jugas are in peril at that time, and is doing the thing I would consider the appropriate thing then by warning them. And then there are texts between her and her older son that say, hey, if you see your brother, get down on the floor because I'm concerned he's going to shoot up the house. And these are not joking. These are texts sharing with family members about how unsafe they feel. So this new narrative, I just have a gun to keep myself protected, is hogwash that is absolutely counter-indicated by every bit of social media that we have that is in real time. And it's a new narrative designed to create sympathy for this predatory act and predatory individual. Judge, there is no remorse in this case. It's stunning that there is no remorse in this case. And it's too late. So some crying speech today or some recitation from a defense attorney, oh, with us, he's really remorseful. It's too late. It's too late. There's ways you could have acted before now that don't show that it's just another manipulation by you today. Think of how rare it is that someone can murder another person. And then think about the character you have to be able to murder someone you know. And then take that here. Say, who out there on the planet has it in them at any age that they can murder someone who has cared about and loved them by looking them in the face and doing that? Who can try to kill someone who has had you over for multiple holiday dinners, who's welcomed you in their home, who's bought you gifts that where they were thinking of you? Who can do that? Who is it on the planet who has that capacity in their character? And are those the individuals that we as a community and that the Jugas on a personal level should be protected from? So this is my final thing to the court. I asked the court in your long years on the bench to think about if you've ever had a case where these three factors were higher up when they're added together. One, have you ever seen a case with this much premeditation? Two, have you ever seen a case where more individual people were skillfully manipulated to help you commit a murder? And three, have you ever seen a case, Judge, where there was more of a profound effort to corrupt the justice system at its core at a jury trial? And I'd suggest if you take those three things together, that this court has never seen a case where those three factors are elevated at the height they are in combination. And from the state's perspective, that's where there's the matter in terms of danger to this community. And I ask the court to place this defendant on a sentence where he will never be returned to this community. Thank you.
Oh, what's his last point? Hell.
Mr. Johnson?
Thank you.
So before he speaks, there was a lot of prosecutor speak in there of worst ever. Have you ever seen this? Never seen it before. Those are a lot of prosecutor words. If you start paying attention, somebody made that comment about, I don't even know who it was. Like, I don't even remember what trial I was watching or who. But then I started listening, and every prosecutor is like, worst case ever. And oh, by the way, maybe don't call the judge old repeatedly. Yes, and make sure you throw in the word hogwash. Like, when was the last time I've heard that word? I think the last person to say that word was my dad, maybe, about something. Don't hear it every day. All right, let's hear what this little guy has to say here. But, Gabby, if everything he's done in jail is true, and again, although I can say Gravely's been okay here, I have seen him not be okay. So I can't just take him at his word. If what he has done in jail is true, that's horrible. If he had somebody write that family a letter basically informing them of all the details of their life, that's horrible. So, well, I don't know what he should give him, Adair. This guy he's got zero to work with, so he's trying. I hope your ears are okay if you've been listening to Gravely. I had to take mine out again. All right, let's see what the defense has to say.
Your Honor, it's no surprise that we are asking the court to make Ms. Fuller eligible for release at some points in the future. There's no doubt that this case is an absolute tragedy, and the court has received a number of letters from the Juga family, from supporters of theirs, describing the level of loss that they feel, the level of pain, physical and emotional. And so I'm not going to pretend to understand what that is. I can appreciate that life would never be the same going through this situation. If this had happened to one of my children, I would be an absolute mess. I would be a disaster. I would be filled with rage. I would be filled with anger. I would be overcome with sadness. I have no doubt that that would be the case. But that's why if that had happened to me or someone that I love and that I was close with, the decision about what the punishment should be would not be mine to make. It falls to a judge. To listen to all sides of this case, to act impartially, to take the emotion out of the situation, decide what is fair, and decide what is just. And that's part of the heavy load that is given to judges, to use their judgment, to not be scared of criticism, to not be scared of the public, to not be swayed by those things. At the trial, in my closing argument, I said to the jury that part of what their job was to not be swayed by sympathy, prejudice, or passion. I understand this is not the trial and you are not the jury, but I think that sentiment continues to hold true. Mr. Gravely talked about remorse. A number of the letters talk about, from the Juga family and their friends and supporters, talk about the lack of remorse that Martice exhibited. And I think Mr. Gravely is accurate in saying that it would be hollow if he did. And I think that's true. I don't think that even if that had occurred, even if there had not been a trial, I don't think it would have made anyone feel any better. I don't think anyone would have believed Martice. They have every right to be mad at him. They have every right to hate him. And I think the reality is that there's nothing that he can do to change that and to change that opinion. I think that all too often we ask way too much of the criminal justice system. We ask the criminal justice system to provide a fair trial, to provide due process, to honor a defendant's constitutional rights, to figure out the correct punishment. And we also use it to try and find healing for victims of crimes or the community. And that's really not what it was designed to do. And I think it's asking too much of the criminal justice system to provide that healing and that closure, because that's not what its original design was. In May of 2019, Martice Fuller was 15 years old. He had no juvenile court history. He was an honor roll student. He was a varsity athlete with lots of potential. He was working part-time jobs. He was a talented young man with a bright future before him. And the courts received a number of letters from his family and his friends describing
Just like Kaylie.
that person and that child. And I understand that what's been presented to the court in the trial is a completely different message. But I don't think that discounts what his family and friends have said about him, about who that person was and who that person is and continues to be. I wanted to respond to a couple of things that the state had mentioned. One was a letter that was sent from the jail to the Juga house. And I just want to note that that matter has not been litigated in a court. There's not been an opportunity to challenge that, I guess, in the formal setting or in the correct setting. And Mr. Gravely made a number of comments about how the Fuller family has some of the things that have been said now at this point. And there's certainly, this case is not about what they did or did not do. I cannot think that there's a way to accurately predict how any of us would react in a crisis situation such as what they faced. And I don't think whether they believe the state's evidence about what happened or didn't happen, I don't think that's the issue today. The issue is, what's the correct sentence? What's the appropriate punishment? I know the court is well aware of what its obligations are, what the Galleon factors are. And part of sentencing is to figure out what's the appropriate sentence. I know in most cases, the court has to first consider probation. We're not in that situation, I understand that. But I think that what the inference is from the case law is to say that the court is to impose the sentence that is the least restrictive needed to accomplish its goals. And here we believe that that means release at some time in the future. The legislature could have decided that anytime someone is convicted of first-degree intentional homicide, that they can never be released from prison. That's not what they did. They said that a judge can decide that at some points in the future that someone is eligible to petition for that release, that it's possible to do that. And here we have a child. We have someone who is 15 years old in May of 2019, who less than a week ago turned 18. And as is mentioned in the sentencing memorandum, the United States Supreme Court has talked about the differences between adults and children when it comes to sentencing, and that even when juveniles commit terrible crimes, they should not receive the harshest sentences, such as the state's proposing. That children are different. Their character is not as well formed. Their traits are less fixed. And quote, from a moral standpoint, it would be misguided to equate the failings of a minor with those of an adult, for a greater possibility exists that a minor's character deficiencies will be reformed. And so, Your Honor, we're asking you to make Martice eligible for release in 25 to 30 years. He is a child, and I do think, and the Supreme Court has recognized, that there's a greater possibility, greater potential for reform. To give some type of reason to be better, to do better, for hope. And the state was right. I'm going to mention hope. To give someone who is 18 years old some ability to think that one day they may be able to walk in the world, to do something, a small thing, to make up for the tremendous pain and sorrow that they have left behind them, and to allow them that opportunity. And so that is our request and our recommendation of the court, is to make
Johnson, Mr.
Come on, internet. Is he going to speak?
Judge, Mr. Fuller's prepared a statement that he asked that I read on his behalf.
Okay.
Um,
As you know, court reporter, read slowly, okay?
Yes.
I can't believe he's not even going to read it on his own.
Martice writes, wholeheartedly, I wanted to write this giving my sincerest apologies to this family I once shared time and love with. Truthfully, I am sorry about the pain you've all suffered through this, but more importantly, the loss of my ex-girlfriend, Kaylie, that I loved too. So I am sorry. Despite the hatred that is against me, I still am sorry. But I have to continue to stand innocent because I am. And I know that I've barely showed emotion throughout my time, but in all honesty, it is because it's hard to have tears left to cry knowing my mom lost a son, one of her children too. But I am sorry, and I hope you all can eventually see in your hearts and vision that I am not the person the media has made me out to be. Thank you for the chance to hear me out.
We didn't see any of the media. And we
Thank
still
you.
do this.
Your Honor, I believe the defendant has been incarcerated for 743 days.
Thank you.
And we ask that restitution be to be determined.
Any objection to that?
No.
Okay. Today is a final day for me in this tragedy that you, Martice, caused for this family, the family of a young girl that you murdered, a mother and a wife that you attempted to murder, and their family, and a community that watched in horror as the story of your ruthless, depraved, and violent story unfolded. It was unfathomable for all of us to think that a boy 15 years old could plot and plan ruthlessly to kill Kaylie and her mother. There's no final day for them, their loved ones, or for your own family. Your actions killed a young girl, wounded and scarred a mother, damaged 2 brothers and a father, and that damage will not end emotionally, physically, or societally. Their burden is enormous and endless. This was a family that warmly admitted you into their circle of family and friends. They ate with you and included you in family activities. They were good to you. They considered you a friend of their daughter. And when teenagers of all ages choose to date and be with friends with other people, you decided you would not allow Kaylie to make that choice. A choice of adolescent friendship that probably every person in this room has made many times before they marry as an adult. Instead of enjoying that friendship that you had, you decided it would be terminated, like a hitman. We saw the plan, the calculating moves that you made to carry out your hatred and your vengeance, the efforts to cover up your heinous act. We also saw the decency of a community in testifying in this case. We heard of the efforts of the school district to put an end to your controlling and compulsive efforts to wall off this young girl from others. You would have none of it. I saw you assert your constitutional rights in a trial that you had every right to do. But I watched as Mrs. Juga, the woman you attempted to kill, testified bravely while you showed not one semblance of compassion or remorse. You sat emotionless until the verdict was returned. You seemed to have no ethos, no regret, no sorrow, no empathy. You are for you and no one else. Much time has passed, and now you're 18. And what have you done since then? You attempted to tamper with my jury. You gathered other inmates to brutalize other inmates. I don't have any knowledge about this other letter, but certainly that isn't a star. You have not shown any attempts to acknowledge your wrong or express remorse in your actions. You are a very dangerous and a damaged human being. You have the soul that God gave each one of us, but it seems it is not bent toward compassion, kindness, or remorse. I'll pray that it be repaired in some manner, but I don't hold the solution for it. These crimes were not the impulsive acts of an undeveloped child. These acts were performed deliberately and with much thought and planning. You do not stand before this court with a damaged childhood. You don't have a history of mental illness. You're intelligent, you are socially developed, you are athletically gifted. You have no prior record. People believed in you and your talents and your future. Your parents worked on your behalf to raise you well. You rejected them. You rejected the coaches who could have helped you. You rejected the school's directions. You rejected the rules of society, and you rejected the rule of law in the processing of this case. The taking of a human life is the most serious of crimes, which is why the legislature has said it statutorily as they have. The attempting of taking the life of Mrs. Juga was a continued part of your plan to cover your murder of Kaylie. And luckily for her, you ran out of ammunition. I don't have any ability to trust that you will never commit these acts again. You continued violent behavior in the jail. The court has no trust whatsoever that what brought you to this murder and attempted murder is repaired or repairable ever. Rehabilitation is not likely in my mind. I hope that you can right yourself in your life, in your daily life, but it won't be among the community. It was all too calculated. So in the interest of protecting the public, acknowledging the seriousness of these acts, the court orders that on count 1, you are sentenced to life in prison without eligibility for extended supervision. You are, on count 2, the court is ordering 15 years in prison, followed by 6 years of extended supervision, consecutive to count 1. And on count 3, the court orders 5 years of initial confinement and 3 years of extended supervision. Count 2 and 3 are concurrent with each other, consecutive to count 1. You are convicted of a felony. The law prohibits you from ever owning or possessing a firearm. If you are found to own or possess a firearm, you would be charged with felony offense, which carries 10 years in prison and a fine up to $25,000 or both. You're required to submit your DNA sample if that has not already been accomplished. You're not eligible for most of the programming because of the nature of these offenses. And I'd ask that Mr. Johnson and Ms. Scheidegger please accompany him to the go over post-conviction in the other room. Credit for 742 days, and restitution is held open.
Thank you, Your Honor.
You're welcome. Now, everybody's going to sit tight till we get an orderly way to vacate the courtroom.
Yeah, but she still has to do it, and they run concurrent, or they run consecutively, the other two to his life.
I don't have that consecutive and concurrent marked very well, but you could probably do it.
He's not getting out. After he, yeah. Her dad was like staring him down. Don't blame him. I don't know how he sat there. And hearing the stuff from his family, I don't know. I feel bad for them, but how do you guys are trying to act like it's okay or not okay, but cover it up? Who's that? It's purple. I don't know, Hamilton. We heard closing arguments.
Go back and listen to sentencing. Closing arguments was an hour and a half of Gravely yelling. They were, for Gravely, it was a good closing argument, but it went on and on and on. If you go back and watch the verdict, you will see emotion from him for once. He cries pretty hard. And he did not use a mic. Old Gravely was across the room at one point. But they get to see their son. They can go visit him. He's obviously not making good choices in jail if he's been fighting and getting other people to fight other people. I thought that was that guy's underwear. I was like, good Lord. Yeah, he didn't even read. I don't know when you got here, Hamilton. He didn't even read his own statement. He had his lawyer read it. And you think about it. I don't know, Adair. We've been talking about this. Yeah, we got to figure out the other thing is too. So Friday, we're just probably going to kind of just do a chill thing and maybe watch some like police chases because I don't have anything. Monday, possibly if they show it, will be the pretrial hearing for the Tucker case in Florida. And then we'll get a date for when that retrial is going to start. That is my next thing. I just don't know how far out it's going to be. We have, what did I tell you guys? A sentencing May. I had them all written down. So we've got May 5th is Adam Montgomery sentencing. Or do I have that wrong? I have it written down. I just don't remember where I wrote it down. And then April, is it May 4th? I don't remember. I have it written down. Adam Montgomery sentencing is in May. There it is. May 9th. And then Jesse Krzyzewski, the eye drop person, her sentencing is finally coming up in April. So we'll be doing those. Trial-wise, we've got, if it starts, Sarah Boone coming up in May. We've got the Tucker retrial coming up. I'm hoping those two don't run into each other. I hope that I hope one starts and then the next one starts and that they don't push over. So yeah, Sarah, but am I missing somebody? We're waiting for Chad Dorman. He's the guy that unalived his 3 kids in the front yard in Ohio. Brian Koberger has been delayed until summer of 2025. And there's no date even on that. It's just summer. Are you talking about not Karen Reed, although that would be an interesting trial. What is her last name? We just talked about her the other day. The one Jose Baez is representing. Karen, it's Reichen? I've not heard anything on Billy Wagner. Are you talking about the woman that unalived her husband and then wrote a book about it, Adair? The grief book for kids? Her last name starts with an R, but I can't remember it. I have no idea when the Karen Reed trial is starting because that is a crap show, to say it nicely. Yeah, I don't know. That one will be interesting. One, because I know people don't like him because he got Casey Anthony off of her trial. Phrasing. But he's a good attorney. And I like to watch good attorneys work. defense or prosecutors, doesn't matter to me. So yeah, all these people keep screwing around and getting their trials delayed. Brian Koberger's attorney said they didn't even know if they could be ready in summer 2025. Yeah. I would think Chad Dorman's hearing or motion to suppress should come back soon. It's been 2 weeks. I think it might be, if it comes back another couple of weeks, that'd probably be about right. I have that trial probably is still a ways away. I saw that. Yes, it's all hogwash. Everything is hogwash today. I saw that one. I watched a little bit of the opening statements of the one in Tennessee. I was trying to figure out if I could catch up on that and be caught up by Monday, but there's no way. We would have had to start it today, and we needed to finish this one up. But I saw that one. I'll take a look and see if we can catch up. I want to be. I don't know. I don't know what's going to happen Monday with Tucker. And then are they going to allow cameras in Chad Daybell's this time? I thought it was crap that they didn't in Lori's. Hogwash is an old, an old-timey word. It's not one you hear anymore. Whoop. Sorry. Okay, so we'll just have to keep an eye out, kind of see what's coming. I was looking and looking. It's like we missed probably a window, I guess, this time. I did want to watch this trial, though. Even when I saw it. I kind of didn't when I saw it was Gravely, but I really wanted to watch it because the people involved were so young and I could relate to a lot of it. So that's that. I'll look. Maybe we'll play the no, I'll be on. I will be back Friday. What if, it may just be police chases off of a news channel that has a whole page of them out in California because they are very they're not rare out there. Maybe we'll play the last witness in the Rust trial because that's kind of gotten me curious. I've not watched any of it. Just read stuff here and there. I want to find out what this other thing is with Martice. What the other ongoing situation was at the time that he still had the no contact order was supposed to have a no contact order with his family. She lifted it, but I don't know how that works if one lifts it and the other doesn't. She obviously wasn't the judge for the other one. Oh, here. Yeah, if you find that, let me know because I was looking for body cam stuff, but I can't do somebody else's page. So news I can do, but I can't go get somebody else's YouTube page without their permission. But wasn't that his third charge? One for the unaliving, one for the attempted unaliving, and one for that? Was that not his third charge? And by the way, I started to say something because it just hit every time they said it, it just hit me. When the mom met Martice in the hallway, he could have taken her out right there. Hit her here. But he took his hand, he took his pen, and he lowered it down. Thankfully, he did that. But they could not be that far apart. I don't know how well you would have to be able to click your pen to hit somebody right here when you clicked it. If you're all getting what I'm saying. The fact that he lowered it and that in itself saved her, as well as being able to get into just, when he was like, well, she got behind a locked door, that saved her. Now you just click your pen and it goes through the door. So that didn't necessarily save her. He ran out. His pen didn't click anymore. That's what saved her. But I feel horrible for her. I don't know if I could move because I would feel like I was leaving her behind. I don't know that I'd want to stay. All right, Hamilton, I'll look at that. Because a lot of when I looked at body cam stuff was all on other people's pages. So I told you about Brian Koberger, told you about Chad Dorman. Monday, we'll see if Tucker's on. I don't have a good feeling about that. Carmen and I were. It is stupid, Adair, and I can't even put your comment up because I would risk getting in trouble. It's absolutely stupid that we have become so sensitive that we have to use stupid words about a horrible thing that was done to a person. And in this situation, whether it's a child, everything we've covered so far, for the most part, the majority of stuff that we've done on here has involved children. And to say that, well, you clicked your pen, it's so dumb. And it takes away from what actually happened to them. I don't like it, but nobody asked me. And I hate it, though. I hate that we've just, I don't think we have all become so sensitive to that word and to, it wouldn't even let me type out when I had to put the red liquid coming out of my ears because it wouldn't let me type out the B, L, two same letters in the middle and a D at the end. Wouldn't let me type it out. Wouldn't send it. When I typed out a whole bunch, it didn't say anything in there. I don't know why it wouldn't send it. But I mean, yeah, like describing this one when the person I can't remember her name now, from Utah. That's like when I was like, he pow-powed her with the pew-pew. How else do you say that? And then they're like, you just made that sound adorable. Funny, but I hate it. Because it's not adorable. They deserve better. Yeah, you can't have that either. I don't think. Don't put that up on my page, Adair. Yep. Gabby. Thanks, Gabby. Yes, Hamilton, you're correct. It's stupid. And if you only watch this stuff on Court TV or Law and Crime, then you don't understand. A lot of people don't understand that it's out there and that you can't say those words because they can. But I see people not using the words in the chat, so I don't know if their chat rules are different or if those people just watch stuff other places and know not to use those words. But I've just noticed if I type in something, and if I say Adair won a gold medal, and I typed out he deserved that, it wouldn't send it. It would just I wouldn't be able to. I would have to do what Gabby did and I did today, type it out, because apparently telling somebody they deserve something is not good, whether you mean it in a good way or a bad way. Thank you, Adair. I try. So I don't know. I will tell you, I talked to Carmen for a really long time this morning, and her and I we talked about a lot of things. The mom talking today in that sentence, I was like, I could put myself in her shoes if Carmen was gone. Or Brandon was gone. About, that's your friend. I mean, I talk to my kids all the time, and not being able to talk to them would be horrible. Yep, but it doesn't type it out. Doesn't type it out. It just puts little stars. So I guess that's okay. I don't know. You get 24 hours of lost privileges, Hamilton? You naughty girl. What are you doing? Spicy. It is gotten really bad. Absolutely ridiculous. Oh, it didn't send it this time? Try to get me in trouble, Gabby. Goodness. But yeah, there are channels that don't worry about it as much. They've also got huge followings on here and on Rumble, so they don't have to. Yeah, there's no way that you threatened anybody. But I don't have that luxury, so I'm being very careful and follow all the rules. I remember laughing at that day. That was the day. Yeah, that I felt it was so funny because it was out of the blue. And I was so unexpected, and it really made me laugh out loud at a really horrible. And I thought, oh, okay. And yes, it is because you're so nice. You are. Yes, you are too nice. But yes, oh, hopscotch. And the day that Gabby yelled like an old man for people to get out of her yard. Get off my lawn. That's what it reminds me of, Gabby, when you're like, hey, get the F out of my trash. I think we were all there. It's like the camera's going, woo, come on, camera, come back. It was so unexpected. Why is my camera's done for the day? Come on. Hello. I don't need to turn the light up. But that's what was so funny about it, is because it was so unexpected. And it was just so funny. And the day that you were telling people to get out of your trash, I sat there and stared at that comment. It was kind of like the day you accidentally said something about 11 herbs and spices. Not to hear, but probably to your husband or something. And I just stared at it and stared at it, trying to make sense of what you were trying to say. And then you came in, you're like, talk to text. Because I was trying to figure it out. Like, is she talking about 11 herbs and spices again? We've already talked about it. She's already talked about it. Pop size is better, we know. So, alrighty. I guess that's it. But yes, you named the guy Colonel. I don't know how that motion. I don't know. That motion to suppress, I thought was probably a stupid one until that guy didn't read all the stuff. Then when he didn't read all the Miranda, I was like, yep, you might be screwed now, dude. You might have just, not that he won't walk out. It's not one of those technicalities that's going to be like, okay, well, we can't charge you. It's not one of those types of technicalities, and he's on body cam. So unless they just take all the body cam footage out, which I don't think they would, but they could, I guess maybe whatever he was talking to on that, even if you silence the body cam footage and don't let anybody hear it, they're all right there. The wife, the stepdaughter, everybody, too many witnesses. He's not gonna walk. Yeah. Yes, it was just laziness. Absolute laziness. And yeah, we were thinking this guy's gonna explode because his blood pressure's so high. No, he knew he screwed up and was waiting for the hammer to come down on him. And it did. Yes. Well, we've learned that LWAP equals no IHOP. Right? I had to look at that one too for a minute when you first put it up, Derek, because I kept thinking it was an I. I was like, what is it? Then it clicked. Yep, won't be any IHOP for him. The only thing I was I was thinking, only IHOP's going to be when he goes hopping out of the shower trying to get away from somebody. Yeah, but every time, Hamilton, every time it should be by the book. Every time. So you don't run into that. So somebody doesn't, where there isn't maybe good evidence. I mean, this is just cut and dry evidence. But yeah, exactly. So every time should be by the book. Yeah, so, sorry, Gabby, I know that was bad. Yeah. I just had it when you said IHOP, I was just picturing him hopping out of the shower. I don't. Absolutely. Like, just do your job. You have a card. Read it. It's right there. Just read it. Yes. And it hurts. Legos are the worst. They are the worst to step on. Gosh, I didn't know something so small could just cause so much pain. And you always hit them in the middle of the night when you think your kids picked them all up. And they didn't. And you had to go walking down the hall in the middle of the night and you about crumbled. Like, alrighty then. You want to yell out, but you can't because you don't want to wake everybody up. I've been to that ball game a few times. I'll start at 11. I don't care. Because it's not going to be like a 5-hour stream. So if you guys are all good, I can start at 11. That'll give me a little bit more time to get stuff done. that I didn't get done today because I was talking to Carmen. She waits. She knows like exactly when her dad leaves, and then my phone rings. Finally, I told her today, I'm like, it is 9:00. You need to go to bed. You have to work tonight, and I need to go get ready. I'm going to be late for my own show. Yeah, that's fine. We can do 11. It's fine with me. I'm waiting for Hamilton to tell me what to look the article up on. Oh, I want to see if I can too when I can look up stuff. I want to see. I have like a lot of notes, but they're not in any good order. But I do want to see what this other trial or what this other situation was. Oh, yikes. Okay. Yeah, no problem. It's fine. We're not, like I said, it's not like we have a set schedule. Have you guys seen, I think I saw that, I haven't watched it, but I think I saw, I don't know if anybody watches Law Talk with Mike, but he had this guy on once. This guy, Kim Blandino in Vegas, has been in to court since like 2020 on all these stupid charges. And he is ridiculous. He tries to tell his attorney what to do all the time. And this attorney turns around and's like, I know. Chrissy, where you been? Where you been? You weren't here all day. You missed hogwash. You missed getting yelled at by Gravely for an hour and a half, plus another 30 minutes after that. She's probably like, I wouldn't say I missed it. I know. Are you guys drying out there yet, weather-wise? It was just me and Gabby at the beginning. Well, make sure after, if you and Hamilton go back, anybody goes back and watches the replay, oh, maybe it'll be on the news channel. I'll tell you which one it is that I follow, that I have marked. Make sure you watch don't just turn it off once the verdict's been read. Because if you'll see emotion for the first time from Mr. Fuller. Emotion for himself. You realize all those tears were for him, not anything that he did. Oh, there's one right now. Right now, it's going on. Hang on. Yeah, it's a box truck.
Multiple agencies, and for the most part, everybody has taken the same tack, which is track the vehicle. But how do things change for all of these agencies based off of what we just saw between the two box trucks? Because I still don't see any CHP.
It's two box trucks?
Yeah, I mean, there are a couple of things going on here. One, the unpredictability of the driver. And we've seen that. Trying to pass a vehicle, ramming a vehicle, getting off the freeway, getting on the freeway. Totally unpredictable. The law enforcement seems to be in a tracking mode as the weather is deteriorating. With rain, police helicopters that normally would be able to follow with low-lying clouds and fog, they may not be able to. So in this case, it's going to be a kind of wait and see game. Maybe you can get some CHP ahead of the game because it is on the freeway to follow this person. But I don't think they're going to actively engage at this speed.
Why are people trying to keep up with him?
And you said earlier a spike strip would be their only possible avenue of stopping him, but with the rain and the other vehicles on the road, that's not likely.
What's that white
The nice
car?
thing about the spike strip is
Mercedes.
once it's deployed and the little metal, I'll call them like straws, will then bed into the tire. It lets the air out very, very slowly. So it's almost like a controlled stop. But we have seen vehicles run on rims for a long period of time with no rubber. So it's not a panacea. It's not the solution for everything.
Well, and if you look at this box truck, it's got 4 wheels on the back, if I'm looking at that correctly. So that makes it, is it 2 there on the back? I can't, I thought it was, but yeah, it does look like there's 2 on the back and 4 on the back. So, now that makes that difficult. And, you get the front, okay, but you're going to have to deflate upwards of 6 tires if you really wanted to get down on the rims.
Yeah, and the other thing, too, is to deploy the spike strip, you have to have a safe operational area, not just for the deployment, but for the officer who's going to deploy it, too.
Okay. That white Mercedes.
That's one of the things I was thinking about earlier, because the deployment of the spike strip is not just lay it out on the street and step back safely and watch. It usually is done in between one car coming by and another car coming by, and the officer has to toss it out there.
He's on
so
screen
with
now.
an
He's
unstable
really
vehicle like this, you're really putting the officer at extreme risk, because if they swerve to miss that spike strip and tip that vehicle over, that could be life-threatening for the officer.
Yeah, and one of the things we're seeing is the weather deteriorating rapidly as they move up toward Ventura County, heading up toward Santa Barbara, Oxnard. So with the low-lying clouds, law enforcement may just have to give this up and just kind of watch on the on and off ramps as this vehicle goes by.
Well, Bruce, here's what we're going to do very quickly. The stream is going to continue with this. Giovanna and I are going to pause. We have some work that we have to do on ABC 7, but then we will rejoin you and we'll continue to follow this. So we'll be silent here for about 2 to 3 minutes, and then we will rejoin the chase. But the picture here on our stream continue as authorities monitor this box truck, which was reported stolen about 2 hours ago.
It was just past Carmen Drive. Where'd the white Mercedes go? I think he left. I'll tell you who has some crazy police chases. I don't know if you guys watch On Patrol, but don't run from the sheriff in Hazen, Arkansas, because they don't back off. And he says, if you run, we will chase you and we will catch you. And his car goes 140 and handles very nicely. One thing I'll say about LA or about California drivers, Chrissy, now you guys have had enough rain that it's probably cleared off the roads, but a lot of drivers out there don't understand you need to slow down a little bit in the rain, especially when it very first starts raining, because there's oil. What are they doing? And it's really slick. And they're like, why did I hydroplane? Because the road is slick. Oh, sorry if you can see the comment. That's going to be annoying. How about we do that? There's some traffic. I mean, that would be a lot of traffic for me.
So it just depends on where you are. In Arkansas, they can chase you, and they will. Here, it depends on where you are, where the chase policy is. A lot of people know that you can't chase, and so they do what they want, get you chasing, and then know that you won't. Yeah, you got some crappy weather out there. Well, there we go. What is that thing? Is that a drone? Is that the helicopter? I'm lost. I know. That grappler thing is cool. That thing is awesome. That's got to be a drone. That doesn't look wide enough for a helicopter. You think that's a helicopter? It doesn't seem very wide. But there's steps, so yeah, maybe. Who? I'm not expecting any snow. I'm not much colder. You're 61, I'm 53. No snow here. Johnny 5 is alive. All right, they're not talking. It's just underneath it, Hamilton. Did they lose it? Because if they lost it, that's not going to be good. You suppose when they said, we had a couple things we got to do in the newsroom, they meant they had to go to commercial? Oh, well, there it goes. And that's over. You are. Oh, Johnny 5. I got what you're saying. Hang on. You are probably the only man here, dear. Is that LA? There's a channel on here called Channel 5 Ratchet News. You guys see that? right here. Do you see it? I don't see it. That streamed 8 minutes ago. What's that? Okay. I did not click on the right channel 5. Is it LA? Los Angeles. Oh, KTLA. My mom watched that every morning. You. Well, I don't see. It's not live anymore. That's some stuff I maybe shouldn't put up here. Yikes. Yeah, I don't see anything happening. KTLA. I remember that channel. Do you know that he got away, Hamilton? Mm. All right, well, I'll subscribe. That's not really what I wanted. I wanted the list of my subscriptions. ABC 7 is who we just were on. And that one is the one that has all the chases on there. Yep, nope, they're done. Looks like. Well, okie dokie. Well, driving a box truck at high speeds in the rain, not a great idea. Not good at all. But you know what? It was a little. I hope nobody got hurt either, if that's what happened. But it was a little palate cleanser from being yelled at all day by Mr. Gravely. So, okay. if you go back on replay, you guys, and you get through Gravely, and then Boy Scout does his closing, that's in Colorado, Chrissy. I get so distracted easily. And then Gabrielle does her rebuttal. They deliberate for about 3 hours. There's a question in there, so they want to hear the video. They want to watch the video of where it's really windy, and they're trying to, so you can hear the pen clicking 5 times. I heard it. I only heard it 5. I never heard the last 2 clicks. And then fast forward, and it'll get to the verdict, and then then it goes to sentencing. I think we're going to start at 11 on Friday, Chrissy, if you're around. I know that's early for you. Gabby has a appointment. And then I guess we'll just watch some more chases. Alrighty. It's probably that worse. You said it was a physical, so I felt sorry for you. If it's that. Oh. Anyway, Chrissy, I don't know if you're still here. I think that bathtub thing is that in Colorado?
or is it in Utah? I don't remember. I have looked up so many things. I think a state trooper is accused of unaliving his wife. So I don't know if we can catch up with it, but I'll look. All right, guys. I have nothing else. Nothing left. Well, sorry to rumble, but I think I'm not going to be streaming to you because you were really messing up my internet today. I hate to not do that because it's kind of my safeguard. If everything gets, for whatever reason, would get taken off of here, it's all over there. So I don't know. Let's see what my internet's up to. All right, you guys. 11:30, or I mean 11 a.m. instead of 10:30 a.m. Eastern time, Friday. We're just going to do whatever. We'll figure it out then. And then Monday, we will have to see what the schedule is for Tucker's hearing. So I don't know what we're going to do. We'll figure that out then too. It'll just be fun. Trust me. All right, guys. Chrissy, be safe. If you see any box trucks, run. Hope nobody was expecting a delivery. See you later, Adair, Hamilton, Gabby, everybody else that's hanging out. If you haven't hit the like button on your way out, please. And thank you. And I appreciate it. And we'll see you all